Order, are we good? I'd like to call today's hearing to order at 9:33 a.m. I would ask that we take about a 12-minute recess. We will convene at 9:45. There are a few documents for which the board needs to review, as well as we're awaiting the arrival of two additional hearing board members. So we will go off the record and come back at 9:45 a.m. We're off the record. Mr. Alberto?
Hi.
Okay, we're gonna go ahead and, go back on the record just a little bit earlier, 9:43 a.m. Good morning. We have two cases before the hearing board. One is Baker Commodities, Inc., case number 6223-2. And today they'll be discussing as a motion in limine and then a motion to strike. And the next case is South Coast AQMD versus Valley Plating Works, Inc., case number 6259-1, order for abatement for which we'll take subsequently. Who's here on behalf of the petitioner? Yeah, absolutely. Come on up, my friend.
Yeah, my name is.
Yeah, no, you don't have to rush. Just hold on one second so you gather yourself and then you can reply accordingly.
Caroline Lee.
Yeah, we need to get your microphone up.
Caroline Lee from DLA Piper on behalf of Baker Commodities, the petitioner.
Okay, and who's here for the respondent?
Nicholas Dwyer on behalf of the district.
And also Daphne Sue on behalf of the district, last name HSU.
Okay. Do we have, there are a multitude of exhibits to be marked? So why don't we go ahead and go with the petitioner first? And
There's a moving party in this case, so. Start with them as the.
well,
There's a motion. Your motions that.
yeah, but
District files.
hold on a second. But the petitioner is Baker.
Yeah, but they go.
Yeah, as the moving party, the district, we filed first. We would be proceeding first with most things in this proceeding.
Okay, no problem at all. So what is the,
Sorry. I just want to also state George Jiganis from DLA Piper should be on the remote line, also on behalf of Baker Commodities.
spell your last name again?
My last name is Lee, Lee. His last name is Jiganis, Gigouan. Sorry, did I? Gigounas.
Is he there, Dee?
Yeah, is he online? Okay, so can we bring him in? I see he has his hand raised.
Okay, I am here. Thank you.
All right. So the record is clear that Mr. George Jiganis is present. He's participating remotely. All right, Mr. Dwyer, do you want to give us your exhibit?
Well, I guess I would ask the clerk how we want to mark all of these
Well,
documents.
You're going to be alphabet and they're going to be, according to what the clerk shared with me, there'll be a number.
Okay, we can start with the motion to strike, the district's motion to strike. That could be Exhibit A.
Okay,
There are several attachments to the actual pleadings, so I don't know how the hearing board wants to mark those, but
well, to be very clear with it, if they're all attached to that motion to strike, there would be one exhibit.
okay.
So I know that there are multitudes. This is what 180, 200 pages worth of documents. I would assume that would be part of exhibit A.
Okay.
Okay, is there another exhibit?
I guess motion in limine, the district's motion in limine, that could be Exhibit B. The district's request for official notice, that could be Exhibit C. And for proposed orders, I don't know if you want to separately mark those.
Okay, well, 1 second. So you said that the district's motion to strike portions of, okay, so this one here. Whichever is,
Request for official notice is C, the motion limiting is B. You haven't gotten to the reply yet. have you?
no, this is the, okay, this is the proposed, so. All right, so give us B one more time, Mr. Dwyer, because there's so many, there's several documents that are attached to one another, so. So the South Coast AQMD's notice of motion to strike portions of Baker's permit appeal motion to strike memorandum of support thereof request for official notification declaration, Nicholas Dwyer. This would be which one?
Can you read off the title of that one again?
You have a comment, Madam Clerk?
Motion, right, so we normally don't. No, I thought there was attachments, I thought something that is defined as, is there something that is defined as exhibits?
No, but I know that sometimes within the hearing board, we do mark the pleadings and motions as exhibits sometimes. I think that's what we're doing right now.
So Madam Clerk,
if
you
I'm
tell
not
us what's
mistaken.
efficient. You tell us what's efficient from an administrative standpoint.
But the proposed order to me.
Yeah, I think, as he was starting, the request for official notice, which was part of that, should probably be labeled separately, since that requires separate action on our part, and then the proposed orders.
Okay, and so there are two proposed orders. And so we're going to mark those as, so the first, give us the first proposed order as you have it, Mr. Dwyer, so we were all on one accord.
Well, the first motion is the motion to strike. So then the proposed order would relate to that. I don't know what we want to label it.
Well, you
Our-
labeled the request for official notice as C, so label
Okay.
D.
Yeah, deep. And then the proposed order for the motion in limine, we could have E. And the proposed order for the request for official notice, that could be F. And the district's reply, that could be G.
All right. Ms. Lee?
We filed a single opposition to both motions, so that could be Exhibit H.
No, you won. You're not
Okay.
numerical.
Apologies. That would be Exhibit 1, and the associated exhibits would just go with it.
Okay, so just want to make sure we got this straight. So there's this one here is going to be one.
That's the opposition, that's the whole thing is one, yeah.
It should, that's what we're going to go. The whole document will be.
Yeah.
All right, thank you, Ms. Lee. That was very easy.
May I inquire, Ms. Lee?
Go right ahead, sir.
Are you opposing the request for official notice?
No, we do.
Okay, great.
No, we are not opposing the request for judicial notice.
Okay, and so at this time, we want to ask if in fact there are any individuals, are there any individuals on the line that provide any general public comment or evidentiary testimony with respect to this matter before the hearing board?
Yeah, one person.
With their hand raised?
Oh, no.
Okay, let the record reflect that no one that sought recognition to provide public comment and or evidentiary testimony. Mr. Dwyer, the floor is yours for opening statements.
All right. So it's a little different than our other proceedings. This is just an opening argument. It's not an opening statement. I will not be intending to call any witnesses to prove any facts here. But before that, I just wanted to get that out of the way before I proceeded. Good morning, hearing board members. Thank you for your time. We are here today because the district and Baker disagree that the operations identified in their permit as a trap grease processor and a collection center subjects them to District Rule 415. What is relevant to the permit appeal is how they are operating now. Statements made by the hearing board members or by the parties regarding different operations, for example, without operating as a collection center, are irrelevant. Where we are at this juncture of the proceedings before the hearing board follows prior orders for abatement, a petition for writ of mandate to, among other things, overturn that order for abatement, civil litigation, and settlement of those prior claims. The district is seeking to focus and limit these proceedings only to when Baker decided to cease their animal material rendering operations and replace it with a collection center. The stricken pleading submitted by the district does not remove any language that sets forth Baker's arguments on how their operations as a collection center and trap grease processor is not subject to Rule 415. That is what the permit appeal proceeding should be about. That is what Baker must argue, and that is what the district must respond to if they are to defend their decision that Baker's current operations are subject to 415. Baker is asking this board to weigh arguments made when Baker was undecided on whether they wanted to continue operating as they had previously been permitted or modify their operations. That process played out before the hearing board to retrieve prior testimony from proceedings when Baker had not yet submitted its current permit to be evaluated by this hearing board presumes that Baker knew what it was going to do all along. If that was the case, they would have submitted their permit application much sooner. The point of the district's motion is to prevent Baker from trying to present their evaluation of their options and hearing board members' discussions of their exploration of how they would presume operating in prior hearings as representative of what's in the current permit application. The district has no objection to relying on the conditions from the hearing board's second modified order as reflective of the decision by Baker, which they stipulated to. None of the order for abatement proceedings required Baker to convert their animal material rendering operations to a collection center. That was entirely Baker's decision to do so, of its own volition. To pretend the district and hearing board were basing their discussions and responding to examination based on knowledge that everyone already knew Baker intended to modify their operations presumes the permit should have reflected that pre-decision. No such process occurred. The permit appeal must be decided independently without influence of self-serving select citations laced in Baker's petition. Baker's permit appeal petition, inclusion of background of the importance of rendering, Baker's efforts in supporting those services, and hearings related to different facts and different provisions of Rule 415 is a waste of time and resources. Those prior order for abatement hearings are irrelevant. The only purpose of including those other prior hearings is to confuse the issues with a resulting undue consumption of time. Statements taken out of context are misleading, and it will take time and resources to correct such mischaracterizations. Such matters should be stricken from Baker's permit appeal petition and excluded from the merits hearing on March 27th. The facts were different. For example, the September 27th through 29th, 2022 order for abatement hearings concerned Baker operating its inedible rendering, trap grease processing, and wastewater system in violation of Rule 415, and its permit. All three processes were shut down as a result of the first findings and decision. The April 18th through the 19th, 2023 order for abatement hearings concerned Baker's request to renew its trap grease processing and associated wastewater operations while the order for abatement was in effect, thus prohibiting Baker from operating its inedible rendering. Arguably, under those facts, where Baker was prohibited from operating its inedible rendering and was not conducting collections, exemption 415 L1C was applicable. Again, the exemption found at 415 L1C states, the following facilities are not subject to Rule 415. Facilities that process trap grease but do not conduct inedible animal rendering operations. Essentially, facilities that only process trap grease type rendering are exempt from Rule 415. On June 21st, 2023, the hearing board issued a findings and decision for the first modified order for abatement. Later, Baker submitted permit applications in November of 2023 and included, for the first time, collection center activity. The May 29th, 2024 and June 11th, 2024 and July 2nd, 2024 hearings for the order for abatement concerned conditions for Baker's facility operating with trap grease processing and collection center activity. However, the parties stipulated to those conditions, avoiding determination of Rule 415, applicability by the hearing board. Such a determination from the district in relation to the Baker's permits had not been completed at this point in time. For its permitting decision, the district still needed to consider whether a trap grease rendering facility that also performs collection activity is subject to 415 or not. Under Hearing Board Rule 6D, the hearing board is fully within its authority to strike from Baker's petition irrelevant matters related to the order for abatement. Further, for the merits hearing on permit appeal, the hearing board must exclude irrelevant evidence under Hearing Board Rule 9B4 and may in its discretion exclude evidence if its probative value is substantially outweighed by the probability that its omission will necessitate undue consumption of time or create substantial danger of undue prejudice or confuse the issues, or where matters sought to be proved are otherwise established. For these other order for abatement hearings, even if the hearing board were to not strike the entirety of the material, it should only allow the final written findings and decisions because they have the determination of the hearing board, not the individual statements from the hearing board members which are not relevant. Please refer back to Valero Refining Company versus Bay Area Air Quality Management District Hearing Board, a 2020 case with 49 Cal App 5th 618. It's at page 644, footnote 24. The district's arguments are more fully outlined in its moving papers. Should the hearing board have any questions, district's counsel is ready for any follow-up questions. Thank you.
Thank you, Ms. Lee.
Good morning, hearing board members. We appreciate your time today. So we believe this is a simple issue. The district is claiming that our evidence is not relevant primarily because it believes facts have changed and because a permit appeal is a different proceeding than an order for abatement. However, those are factual arguments, and it is abundantly clear from the district's opening statement, similar to all of its briefing in these motions, that those are factual, substantive issues that get to the merits of Baker's permit appeal, which the hearing board will hear on March 27th, not today. The district should not be permitted to require Baker or the hearing board to exclude evidence simply because the district believes it's irrelevant. And we should not convert these procedural motions into a motion on the merits as to debate whether facility ceased rendering on September 30th, 2020 upon the first order for abatement or not. The reply brief again confirms that these are purely substantive positions that the district is taking, and it's not proper to exclude evidence merely because they believe it's irrelevant. And remember, we're discussing evidence of district testimony and hearing board decisions concerning the application of Rule 415 to this facility after rendering had fully ceased and what conditions mitigate odors from Baker's actual current operations of its collection system to date. There should be no doubt that this evidence is very relevant to the question of whether the district correctly interprets Rule 415 to apply to the facility after rendering has fully ceased. And that's what is the subject of the permit appeal. The argument that this evidence is so voluminous, it should be excluded is inaccurate. As can be seen from our opening permit appeal and our single opposition to 2 district motions, Baker has narrowly tailored its presentation of evidence to what it feels is relevant. The district is entitled to do the same. And Baker's evidence shouldn't be excluded solely by a threat that the district will have to introduce the entire lengthy proceeding regulatory history at the site, and that's so voluminous that the district will be forced to delay, the hearing on March 27th, and because the district would have to do some work to respond to the evidence as we present it. Baker is entitled to a full and fair opportunity to be heard on its permit appeal, and the hearing board is fully capable advising parties to move along if the hearing on March 27th belabors any particular issue. That's not a reason to exclude relevant testimony at the outset. The standard for Rule 415 application to the facility should be the same, whether it's in an order for abatement proceeding before the hearing board or whether it's in a district permit. And again, if the district disagrees on our facts, which it does, it should explain and distinguish as any advocate would do in any legal proceeding, but that's the purpose of the opposition process on the merits in the March 27th hearing, not these motions today. We don't dispute the Valero decision. That's clear. The Valero decision found that the hearing board should be exercising its own independent judgment to decide whether the district has properly interpreted Rule 415 in a fair, reasonable, consistent, and correct application to the facility's actual operations. The footnote Mr. Dwyer cites to concerns whether the Court of Appeal should be looking towards hearing board conversations to use to impeach later hearing board findings. That's an entirely different stance than we're confronted with today, in which we're asking the hearing board to exercise its independent judgment on the record. Rule 511C supports inclusion of this, requires the hearing board to allow relevant evidence if it's the sort of evidence on which responsible persons are accustomed to rely in the conduct of serious affairs. And so these motions should be denied and the case should proceed on the merits.
Members of the hearing board. Mr. Pearman.
Did you want to see if any reply to that or not?
Yes, did you have a reply? Or you can hold it?
I think I do want to just state that Baker will have every opportunity to present all the evidence it wants related to its current operations. But its past operations and discussions about those past operations and discussions of how the rule applies to those past operations, it's irrelevant. It's a waste of time. You can't take those statements talking about a different way that the rule operates based on those facts and then state that they would apply to these current operations. We need to look at is the current operations and the rule language within 415 and any of the legislative history related to that. The prior order for abatement hearings, none of them ever covered what is that issue for this permit appeal, whether 415 applies to a trap grease processing rendering type facility and a collections facility. That's never been decided at any of the prior hearings. If those prior hearings had discussed that issue, then sure, that would be relevant. But that's not the case here. And that's why these prior order for abatement hearings are irrelevant and a waste of everyone's time to go into. That's it.
Mr. Perman.
So I guess there's two motions, the motion to strike and the motion to limit. They're kind of the same piece in terms of analysis. Some of the rationale for them is more prevalent in like law cases involving a jury versus a non-jury, where the issues mentioned of confusion and prejudice are right. It's less essential in this case, I think, as a consideration, and particularly here where part of the issues in dispute are statements we ourselves have made, and we were all here at the hearing, so we know it happened. So it happened. It's there in the ether, of course. Well, I appreciate all the paperwork that was filed. It seems this is like voluminous sparring. We should just get to the merits in March of the matter. I think that the statements that were cited in terms of the scope of this, one was that a motion to strike is improper unless the challenge material is unquestionably irrelevant and has no possible bearing on the subject matter. A federal case, but notwithstanding these statements by the district, those principles still have some weight. And again, unquestionably irrelevant, no possible bearing. I think it's too broad a brush to say everything that was referenced so far they want to strike is unquestionably irrelevant. It has no possible bearing. The statement also was made by Baker that the courts do not strike the context or a party's view of its irrelevance. It may not strike a narrative statement, which this is sort of, unless the narrative statement is wholly insufficient, a sham and a fraud. So whatever you might think of Baker's positions, I don't think what happened before is insufficient, wholly, or a sham or a fraud. Just a blanket bar on everything is just too broad a stroke to take here. For example, one of the exceptions to hearsay are admissions, where someone said something under oath at one point in time, and then later on, you can use that as evidence. Well, that's always something that we could use. If someone said X under oath and now they say something, they say that that's a fact that relates to the next proceeding, then we can use that as a fact. Similarly, there's things called inconsistent statements. You said something in one proceeding and then you say something different in the other. Well, we have to look at the prior proceeding to use the contrast, and that might affect the person's credibility. So to just strike this broadly as the district requests, I think is not the appropriate approach. I trust my fellow board members that they'll use the law and the facts on the permanent appeal merits to make their decision. And that the prior hearing will not be relevant unless someone shows it is in that context. I can't speak for Mohan, but I've been quoted in the papers here. When I rule on the merits hearing, if I say something that I said before, it's because I think it applies in that context. If I repeat a statement, then you should call me at the district that, are you based on the testimony today or something that happened before? But I can segregate the two, and I think my fellow board members can do that. I think the chair, as just indicated, can control the proceedings. If it turns out, as you present the law and facts before us at the March hearings, if the prior material is truly irrelevant or the time that it's taken versus its relevancy is not worth it, the chair can put a stop to it. The chair can at some point say, now show us the current facts that relate to the permanent appeal and don't rely on the prior stuff. So I don't see how the district is prejudiced at this time. And I would say that if we deny the motion, we should do it without prejudice, not that they can refile the whole motions, but that again, in a particular case, they can appeal the chair that that material being referenced is no longer relevant or the time spent exceeds its relevancy or value and that we should move on.
Mr. Dwyer, did you want to respond?
I did want to respond to some of the case law that was cited in Baker's opposition brief, including the Stevens case that Mr. Pearman brought up, that talks about improperly striking a narrative statement. I feel like it's very important to kind of understand the context of that case, because that case involved a very different set of facts and laws that were not relevant to a motion to strike pleadings. It was striking a narrative statement that was going to be used in lieu of a reporter's transcript. So essentially it was a summary of what occurred at a prior hearing in lieu of a transcript. And it was going to be struck based on another party's claim that it was irrelevant. But that's very different than the situation that we have here. So this claim that standard of a sham kind of analysis would occur here is just it's dishonest. That case and those facts are not applicable to this situation. And I do think that not focusing in on the current facts and allowing all these arguments related to the prior hearings is going to add additional time to those March 27th hearings, several hours potentially, definitely several hours of preparation, having to go through those transcripts in order to make sure that we have the full context and can cite to where those relevant comments are in the transcripts. I had a fear that the thought would be, well, we can fix it on the fly when we're at the hearing, but when we're at that hearing, we will have already needed to prepare for several out these transcripts. It's 10 days worth of transcripts related to those prior hearings. Each of those transcripts was several hundred pages. We will need to review all of that if it's thought to be relevant here. And it clearly is not, because the facts are different. The facts have never been discussed at those prior hearings related to a collection center and a trap grease facility. Thus, I still am of the opinion that a motion to strike here and a motion in limine are worth pursuing, but I understand Member Pearman's thoughts as well. I'll rest.
Ms. Lee?
So we agree with Mr. Pearman's thoughts on this issue. The threat of introducing many days of transcripts and, that should not be used to exclude these important key pieces of evidence that we've cited. To be clear, we don't believe the facts have changed. Baker, as we all sat through those hearings, resumed grease trap and wastewater operations after the April 2023 hearings, and those operations to date have not changed. The fact that the district wants to call them now grease trap rendering operations doesn't change anything from what began in April 2023. And again, we don't want to belabor that issue today because that's not something the hearing board needs to make its determination. But that shows why the evidence is relevant and should be allowed at the March 27th hearing. If the district is entitled and should review the record itself and identify if it believes that's incorrect and make its arguments, but that's for its opposition brief. They've now submitted not one, not two, not three, but will be 4 briefs on the merits of Baker's permit appeal. There are 2 opening motions, their reply brief, and their forthcoming opposition brief, all getting at the substantive factual issues in Baker's permit appeal. These motions should be denied so we can just move forward.
Mr. Balakapalan?
Thank you, Mr. Chair. Oh,
Oh, no, take your time. Go right ahead. And don't tell me there's a ghost in here. Did a ghost do that? Do we need to go back to Ms. Lee, or you were good with respect to, were you able to capture Ms. Lee's statement? Okay, very well. No problem, no problem at all. So this will pretty much be somewhat of a colloquy between the hearing board members and lawyers, so that you can figure out, yeah. And we'll try to slow it down so that we can make sure you're very well. So Ms. Verdugo Prata will go after Mr. Balakapalan.
okay.
So hold on one second, sir. When she
Yeah.
gets set up, then we'll
Yeah.
go ahead and fire it up.
Let me know when you're ready. So, okay. Okay, thank you.
Mr.
All right.
Balakapalan, sir.
Thank you, Mr. Chair. I looked at district's motion thoroughly, and I find it a little troubling only because let me pick a few points, and there's some points I do agree on, but the district said, look at you can include the second modified order. The second modified order didn't come in a vacuum. It came as a result of deliberation and discussion and hearings, where at the second modified order, it was clear that they were processing trap grease, they have ceased rendering, and they were doing collection. The second modified order dealt with the collection, how they, the inspector wanted to go and check whether that facility can handle move the equipment around, and then whether there'll be odor. I think I asked them to look into, investigate, adding something to control the odor. So that was a second modified order where we all agreed, I believe, even the district, that the trap grease processing was not considered at that time. The district did not consider that as rendering, and the collection operation was not considered rendering, and there was an agreement and moved forward with the modification and with the change in the order. So to say you can look at the second modified order, but don't look at anything that led to the order is somewhat confusing to me, because there were, statements and rule evaluation that was made to come to the second modified order, which says you cannot render or render raw rendering materials cannot be processed. So that was very clear. They're only going to do collection and transloading, basically, that operation. The processing of the trap grease was a separate operation. It was not, even at that time, there was no talk of that being considered rendering. If the district had considered that as rendering, they should have brought that up at that time. They didn't. Now to say that, I think in the permitting now, we are looking that as rendering. It's somewhat perplexing to me, actually. And I think the point they made, yes, I agree with the district. The conditions when you do permitting is different from when you do an auto abatement or variance, because in a permitting, you're looking at the whole slew of regulations, the new source review for criteria, toxics, public notice, and other applicable regulation. But you also look at Rule 415. The meat of 415 doesn't change if you're doing permitting or an auto abatement. That stays the same. The evaluation that goes in and coming to the conclusion on whether it's exempt or not, that stays the same, whether it's whatever hearing or a permitting action. So the conditions and I agree that the district said the condition that were put is different in order abatement, because like the condition of limiting the hours of operation of the throughput, because that is not in the rule. 415 is very specific in what you can put. So that's one point I wanted to make. So while the district is correct that the conditions are different, but the underlying fact of the evaluation that the board made and the district made in the applicability of 415 doesn't change. Whether it's exempt or not, that fact doesn't change. Now, the district is making, I'm not sure why, the background, that they shouldn't include that background. I just want to point out, even in the permit evaluation, which I was going to ask later, that we should get a copy of the engineering permit evaluation. Just the permit is actually somewhat useless in a sense, because we have to see what was the engineer's thought, what went on in building that permit, and specifically what he did in the rule evaluation. So in a typical permit evaluation, I can say this from experience, the permitting engineer will do a background. Maybe it might not be the same as what the facility did, but there will be a background. You know, we're not going to dismiss the engineer's background, whatever he put. We don't know what he put because we haven't seen it. But I don't think there's any reason to discard the background that Baker had put in their appeal. There's no basis for, you know, because the background process description is always part and parcel of a permit application, which I think the district appellee said that we should be looking at the permit application and we should see that. And we don't know what exactly is in the permit application, or hopefully we'll get that so we can see that, and also the engineer's review. So I think that I'm not sure why the district is hung up on that background, which is, you know, we just take it, read it, and move on. There's nothing, we're not going to go back and investigate that background. That remains a fact of what is happening. So that's the other point. Now, what was the other thing I was going to say? And I find it a little, it's almost like a Jedi mind trick, you know. Yes, this is now rendering trap grease, you know. The language is put in quite a lot, you know, rendering trap grease, not processing trap grease. The rule talks about processing trap grease, not rendering trap grease, but the district is, oh, slow down, sorry. The district is now, even in the opening said, you know, the process has changed. They're now rendering trap grease. But that's not the discussion that we heard. That's not what we heard during the hearings. And I think it's relevant, at least portions of it, especially, okay, I know mine, I was cited in one of the motion that I cited table P1, which is the summary of the adoption of the rule when they went to the board and they said what applies and what does not apply. And in table P1 under when the proposed rule 415 in 2017, very specifically said exclude stamp grease. And they looked at looking at developing a separate regulation for trap grease operation, proposed rule 416. That was directly in the staff report. Now, if we cannot go back and refer to that fact, then it's troubling because there's some facts we need to go back to the staff report and refer to it and cite it again because that is relevant to even the appeal proceedings because that goes to the root of the matter. Now, Valero and has been cited quite a bit in this and in the past appeal cases too. And really, Valero, I believe, sets a standard of review that the board has to follow, which unfortunately we don't have a rule like the Bay Area, which has laid out what the standard of review is. You know, the two things there on the standard review, one is that it implies a deference to the permitting agency, and two, the district exercise own discretion. Now, I do believe that one deference is gone with the Chevron doctrine that was overruled last year. So the only thing is, you know, the board exercising its own discretion to see if the district applied the rule appropriately. And so to do that, we do need to look at the permit evaluation, look at all the public notice, Title V statement of basis, all the correspondence that is in the folder so we can make that decision. So this motion to strike, except for the change whether the respondent or is valid, I don't see any merit in it, in the motion to strike. I think we should move towards the merit of the case, outline which we don't have, what the standard of review should be, and we should all agree beforehand what our standard of review should be, and when we go to that, and move forward to that. And that's all I had for now.
Mr. Dwyer,
I just want to,
well, hold on one second. Let's allow us to get our, what's your name, Ms. Court? Last name. Thank you, Shaver. All right. Okay, we got you, Ms. Shaver. We're gonna work with you this morning.
I just want to, are you ready? Sorry. I just wanted to point out something that was a factual kind of misstatement by member Balagopoulos related to the district's understanding of trap grease and whether it's rendering or not. We had never conceded that trap grease is not rendering. If you look back at the transcript for May 29th, 2024, I stated, now I think it's really important here to understand that Baker has not completely given up rendering at its facility. At this point, the district does not see a good reason why we need to continue to dig into continued applicability of 415. That could be an inefficient use of our time today at that time. But if the topic does need to be further explored here, I suggest that we have further briefing on that issue. It would be a better use of everyone's time if that was necessary. So the reason I was stating that is because we didn't need to dig into that issue. The permit had not been issued yet. The permitting staff had not fully analyzed whether 415 applies to this facility. They actually had further questions and needed to actually go to Baker's facility and look at how the trap grease operation operated. Now, I also want to point out whether trap grease is rendering or not was relevant too for the prior hearings, but there's a specific exemption for trap grease only facilities. Thus, it wasn't really important for us to dig in on, yes, trap grease is rendering, and because it's already exempt under 415 for facilities that only process trap grease. That was what this discussion was about at the April 19th, 2023 hearings. And that's why those facts, those statements about the rule, it was relevant to those facts at that time. And there's nothing preventing anyone from digging into the staff report and the legislative history and bringing out opinions that they have about the current facts and relating that back to the staff report. There's nothing in the motion to strike to prevent you from doing that. It's to strike those statements because they were related to those other facts. Nothing prevents any member or any party here from going into the legislative history and bringing forth any of those statements that they think are relevant for Baker's current operations. And I just need to reiterate and confirm, we have never conceded that trap grease is not rendering. The issue is whether it was exempt under 415.
Ms. Leisha, you
Can I
offer-
respond to
And-
that briefly? Oh,
No,
sorry.
go right ahead.
No,
I do
Mr.
actually want
Dwyer?
to
Go
state
ahead.
something about the legislative history that member Balagopoulos cited to, that sheet that has
Table B1,
the table 1B1.
B1.
There's a second page to that that includes a new exemption related to trap grease and the unloading process. So to state that trap grease was never intended for 415, when they include a new exemption in 2017, it doesn't follow. You have to consider the entire picture there, that entire context. That's the second page of that table that has that new exemption. So I just needed to point those facts out. I think those are relevant for what we have here today, but we just need to consider those facts and what was discussed at those prior hearings relate to those prior hearings. And if anything here, we should just have the written findings and decisions from those order for abatements. And if there's any need for impeachment of any facts of anyone making a statement that is impeachable, then bring forth the statements that were inconsistent. We don't need to allow that to be part of the entire introduction of evidence at the start. If there is something that's inconsistent, then sure, bring up that prior inconsistent statement. But here, it's just far more efficient to be limited to the written orders, the written orders and the findings and decision. That's what contains what the entire agreement was of the hearing board. The individual statements, those don't necessarily make it into the order, the findings and decision. So it's really more reflective of what the consensus was of the hearing board when you look at the written findings and decisions. So if anything, that is what should be allowed into the permit appeal.
Ms. Shaver, so we're gonna hear from Mr. Balaka Palan. He has a reply. Absolutely. You can turn around, Ms. Shaver.
Oh, if you want, you want to respond because she's turning that way?
No, I thought, no, it's okay. Do you want to respond to Mr. Dwyer?
Yeah, I do.
Okay, no,
Oh,
the
okay.
floor is yours, sir.
Oh, thank you then.
Hold
But
on
it's
one
just that I I had to
Hold on one
turn
second. We
around
gotta get
every
Ms.
time.
Shaver around.
Okay, I think following what Mr. Dwight said, and is that, those are again statements that were made, which you say don't consider, because the second modified order is what we are supposed to consider. The second modified order, when we went through deliberations and so forth, nothing was brought up regarding, applicability, and all that the trap breeze is considered rendering. I know you reserve the option to look into that. So I think just to say, you can go ahead and look at the second modified order, but nothing else. That's what, else except the second modified, so are we not allowed to go back and revisit certain sections of the previous hearing and not cherry pick to pick and say, certain facts that were brought up at that time? For instance, I do believe the manager at that time, Azar Dabri, specifically said, when they're not doing any rendering, they're exempt from 415 because they were not rendering. And at the second modified order, we all agreed there was no rendering of the raw rendered materials. There was just transloading of the material. So though no rendering was occurring, that was the assumption. If we had any inclination that there was going to be considered rendering, then the condition probably would have been different, than what we had approved, because we looked at two different operations: trap grease processing and transloading operation. Transloading operation is not rendering; it's exempt from 415. Trap grease processing is exempt from 415 also. Now, to say that because it's and I think we can debate those during the merit of the hearing instead of now. And so the question is just now what you bring up, is it relevant or not? What previous material. So I disagree that the background is not relevant. I think it helps. I think the process description is relevant. Because to say that the process now has changed than what it was before is also, I think trap grease processing, based on the permits that have been issued over the years, and also remains pretty much the same. We don't know what has changed unless we get the permit evaluation to see what kind of operational change that has been made to trap grease processing that qualifies as a rendering, because in the past it did not.
All right, so Ms. Shaver, we're gonna go over to Ms. Lee, give her an opportunity to weigh into the process. No problem.
So we very much disagree with the district's explanation of the facts here and its relevance, and we'll show that on March 27th. Rendering has ceased at the facility, but that is not the issue today with these motions. And it's hard to understand how any credible argument could be made in terms of efficiency, given how long these motions, the briefing, the hours this hearing is taking on issues that should be deferred to the briefing on the merits.
Ms. Verdugo Peralta.
Thank you, Mr. Chair. I am more concerned about getting this right versus time. While I understand that what we have done in the past is voluminous, and we have spent days on this case. However, having been involved in the permit application when we were trying to get all of them caught up and get rid of the backlog, I was able to understand what the process is, and it is a process. And those engineers are, I take my hat off to them because they have to look at so much information. And it does help when they go out there and in the field and they see what they are going to be granting a permit for. Those permit evaluations, I believe, are very important. And the fact that if we're going to make a decision and we don't have those permit applications to look at, as Mr. Bellico-Palan said, how can you possibly assume what the thought process was into getting that application completed? But let me say this, the standard of review, I truly believe that we need to come to some conclusion on that, because we may be looking at different things and we may be coming to different conclusions on that. Also, I have to say that as Mr. Dwyer did mention, I think it was Mr. Dwyer who mentioned this, that in looking at this today, are we applying what has come in the past to something that's new, a new process, a new way of doing something? Is it different enough for us to take the time to stop this and review this? I'm not sure. I haven't heard that. I'm not convinced. Let me say that. I'm not convinced that we need to do that. And the merits, I think, are extremely important that we will be looking at in March. But the fact that we may be applying what has occurred and been decided upon in the past is far different than what is occurring now. The word rendering bothers me tremendously. That's what we wanted to get rid of. That's what we didn't want to occur anymore. We have been told that it has ceased, and I'm believing that that is the case. But I also want to make sure that that is the case. So, you know, the key pieces of evidence here are within all of that information and all of the decisions and statements that we made in the past. But is it worth it to go ahead and take that all apart and apply it again? I'm not convinced of that.
Thank you. So, Mr. Verdugo-Peralta and members of the board, there were a tremendous amount of documents proffered. I mean, probably a multitude of trees are somewhere bare. All right, just the stumps exist. And so to that end, I believe we need to go ahead and decide this matter for the hearing board. So I'd like to lay up on the table a motion to deny the request to strike portions of Baker's permit appeal and deny the in limine request to exclude evidence related to the order for abatement. Is there a second?
I second.
Second by Mr. Perry. Any further question or discussion on that motion? Mr. Bellico-Palan.
I think, except for the correction on who is the respondent and who is the appellant, I think that's a minor thing, but I think that was also brought up in the district's motion to correct that. But that's all. We need to correct that. I think the Baker has agreed to do that, but I think we need to correct that.
Okay, not a problem. Any additional comments on that particular motion laid upon the table? Hearing none. Dr. Abraham. Aye. Ms. Verdugo-Peralta.
Aye.
Mr. Bellico-Palan.
Aye.
Mr. Freeman, and all votes in the affirmative. The matter is approved unanimously. Thank you guys very kindly. Have a phenomenal morning. Mr. Pearman, Mr. Polikapalan,
You go first. sir.
Oh, I wanted to reiterate. Oh, sorry. Okay.
Ms. Shaver.
Next time you need a swiveling chair that can.
I'm not sure whether other reporters do, but they sit in the middle or up on that side.
They have two heads, so. Or single headed reporting head in a while.
I kind of need that, so I like to look at it.
All right, Mr. Polikapalan.
Okay, I was going to say, to have a more efficient hearing on March 27 on the appeal, we need beforehand to have a clear guidance on what is the standard of review we would use on appeal. We can look at the Bay Area rule, and I think it's actually Rule 8 now, not 3 anymore, which is cited in the citation, but they've amended it. But then I do believe the Chevron doctrine doesn't apply anymore because that was debated at the Supreme Court last year, and it was removed, the deference to the agency. So that portion has to be looked at, you know. And then the second part of it is I think it's essential that we get the complete application folder. As the district said, we look at the Baker's petition application. So yes, we need to see what Baker supplied as part of the permit application, and we need to get the whole evaluation package, public notice, Title V, everything that the engineer did to come to before issuing the permit, not subsequently as they related to the issuance of the permits. So we need those two one guidance and two document, and maybe the guidance can be dealt with during the hearing and what the hearing board can or cannot do, and what its authorities are. But it'll be nice to know beforehand, what the standard review is.
Mr. Pearman, would you like to opine?
Oh, just that I was going to suggest that we might consider another pre-hearing conference, Chair, just to make sure that we have an idea of what the evidence might be presented, and particularly handling any attempt to make a dump of, the entire 1,000 pages of transcript, because I don't think that's what we had in mind. And also this notion of a standard review, if the thought is exactly what is the burden of proof and how that is and what our standards are to decide the permanent appeal, then that's fine. We can see if the parties can agree on what that definition should be by the preliminary hearing conference.
Absolutely. And let's make sure that we provide the hearing board with all of the exhibits as detailed in a form, whether it's Excel or whether it's some form of Word document, but it needs to be comprehensively detailed so there's no ambiguity with respect to what exhibit is what.
And at least a week, maybe a week before.
Yeah, right, all documents. And so, because the objective would be to really have this hearing over in one day. So if we can get all the documents to the hearing board, I know what the Brown Act says, and we're posting pursuant to a regularly scheduled meeting. However, if we're going to have voluminous amounts of paperwork, we do need to be able to have ample time. To be very honest, there was a tremendous amount of reading over the past few weeks. And so we do want to be able to be very conscious and cognizant that there's a lot to digest. And so if there's no additional questions, comments, or concerns, we will go ahead and continue this hearing until March 27th at 9:30 a.m. All right, we're going to take about a 5-minute break, come back, and then we will hear our next case.
Let me search.
We're back on the record. All right, we're back on the record at 10:59 a.m. The next case before the hearing board is South Coast AQMD versus Valley Plating Works Inc., case number 6259-1, order for abatement. And so who's representing the petitioner, which is South Coast AQMD?
Daphne Sue for South Coast AQMD.
And responded is Mr. Charles Pomeroy, correct?
That's correct.
Very well. Okay, will we be calling, just for the record, will we be calling witnesses today on the Valley?
Yes, I
Plains?
will, Mr. Chair.
Okay, we'll get to that in a second. Ms. Sue, you call witnesses as well?
Yes, correct.
Okay, very well. All right, let us mark the exhibits. There are a multitude of exhibits, and so we'll start with the district's exhibits first. Ms. Sue, did you want to call us out? Because Mr. Pomeroy made it very easy.
Did the chair want us to mark the actual petition?
No.
Okay. Then I think I will mark them as I go along. So there's also the stipulated facts and conditions. Does that need to be marked?
Madam Clerk? Yes.
Okay, so
You said stipulated.
yes, the stipulated facts and
Oh, it says not
conditions.
stipulated.
There should be
Yeah,
copies.
that was the one that was emailed this morning.
Oh,
On the way we were getting.
Yeah, on the way.
Oh.
We've perfected reading while we drive.
Apologies, I thought it was dropped off this morning. Let me get it to you now.
Okay. Think I might have to go get a Tesla with that feature. But that exhibit will be that stipulated.
It's important.
Yes, that document will, what exhibit will that be, Ms. Sue?
That would be A.
Wait a minute, I thought you were your numbers.
Oh, one, okay, thank you.
So you're number one. This exhibit is number one. So the district is the petition on this one. So this exhibit, this is the stipulated facts and facts and conditions. This would be exhibit one. Any more exhibits, Ms. Sue?
It should have also been provided something that's labeled attachment C, district's proposed findings and conditions not stipulated.
Okay. This document is number two. Bring it to the hearing board. This number two. You thought that was like scratch paper? All right. Oh, any more, Ms. Sue?
We also will be, part of my opening statement, using a brief PowerPoint. Do I need to pass that out or?
If
Would
you
you like
have
that?
copies, please.
Okay.
Yeah, so we can be able to follow along very easily and make notes, copious notes if required. Are there ample copies for you, Madam Clerk? Okay, so why don't we go ahead and just mark that as Exhibit 3? Exhibit 3. There you go. Exhibit 3. In addition to Ms. Sue.
For the remainder, I would like to do that as I go along during the hearing.
Okay, we'll make certain that we provide Mr. Pomeroy those copies as well,
Yes.
in addition to the clerk's office. Okay, so we'll jump over to the respondents' exhibits, Valley Plating. Mr. Pomeroy did an excellent job providing us with 7 exhibits. Exhibit alphabet A is Rule 126.
1426.
1426. B is Rule 146 excerpted.
1469.
I'm sorry, 1469. Why did you call him out, Mr. Pomeroy? C,
I'll be happy to. C is 40 CFR 267-195, a RCRA example of containment. Exhibit D is a photo of line containment overhead view. Exhibit E is a photo of employee tethered at end of line. Exhibit F is a photo of employee tethered on line. And Exhibit G is a photo of the containment quote, pit, unquote, below line with pipes.
All right, any questions of members of the hearing board with respect to those exhibits, just to make sure that we're all on one accord? Okay,
Apologies, Mr. Pomeroy. Can you repeat what you just said and perhaps reference what it's, I think I see Exhibit 4 listed, so C is Exhibit 4, is that right?
Exhibit D is number 4.
Okay, thank you.
he has listed 5 is E, 6 is F, 7 is G. All right. Okay, why don't we go ahead and conduct the oath or affirmation of individuals are testifying. Please stand. All right. Let the record reflect that there are 6 individuals standing. Do you solemnly state under penalty of perjury that the evidence, 7 people, that the evidence that you shall give in this matter shall be the truth, the whole truth, and nothing but the truth? All right, let the record reflect that all 7 individuals accepted and are hereby affirmed. All right. Madam Clerk and Mr. Clerk, are there any individuals online desirous of providing public comment or evidentiary testimony? Let the record reflect from our distinguished clerk that there is no individuals who sought recognition, both relative to evidentiary or just general public comment. Ms. Sue, opening statements.
Great, thank you. Ms. McCune, could you pull up the PowerPoint presentation?
Excuse me, for the record, who do you have with you?
Oh, this is Cindy McCune. She's a paralegal at our office.
Okay, very well. Thank you.
Thank you, everyone. Valley Plating is a plating facility that has a decorative chrome line and a strip line. Many of the violations that were alleged in the petition are no longer relevant today. Before I go into the specifics, please let me provide some basic facts. Go to the next slide. Valley Plating is a plating facility in Commerce within a quarter-mile of homes. And next slide. Its decorative chrome plating line have tanks arranged in a rectangular fashion. Next slide. It uses an automated overhead conveyor to move parts that are down the line. In general, next slide, please. The tanks are about 10 to 12 feet in height with a walkway above. Next slide, please. And there is a pit below the tanks, which Valley Plating calls secondary containment. As you can see from this photo, there are a couple of buckets. Enforcement staff has had a conversation with Valley Plating staff about what these buckets are used for. The enforcement staff is still evaluating this new information, and we will not be asking to resolve this issue as part of this petition for order for abatement. You could turn off the slides. Thank you. Valley Plating has made changes to its operations since the petition was filed. Further, the district and Valley Plating has stipulated to facts and conditions regarding the facility's operations. Valley Plating, for example, has said it stopped buffing or polishing plated parts. It provided photographs of the buffing area after it's been cleaned. It agreed to condition that it shall not buff or polish plated parts. It has placed new labels on tanks. It has drained tank 41, which contained hexavalent chromium, and agreed to a condition to keep it drained. It has modified certain rinse tanks to be continuously diluted with water. It has provided certain requested records. It has submitted permit application to modify its decorative chrome line, strip line, and air pollution control equipment venting tanks in its decorative chrome line. In short, many of the items raised in the amended petition have been resolved or are being resolved via stipulation or the permitting process. Attachment B to the stipulated facts and conditions provides the agreed upon conditions. To conserve the hearing board's resources, we will be presenting evidence relevant to what is known as Row 3 of the amended petition, more specifically, evidence of violation of Rule 1426. We will only be focused on Rule 1426 violations. In other words, we are not pursuing any violations per Rule 1469 as part of this abatement order. So what is remaining? The parties dispute what is a spill and what is a containment device under Rule 1426. Rule 1469E provides housekeeping requirements. It requires the cleaning of areas or spills to prevent the accumulation of material that can lead to fugitive emissions. Specifically, Rule 1426E3A requires any liquid or solid material that may contain a metal that is spilled no later, it requires any liquid or solid material that may contain a metal that is spilled onto a solid surface, except if spilled on a drip tray or containment device. Rule 1426F provides best management practices. Rule 1426F1 provides that a metal finishing facility shall minimize drag out from a process tank or rinse tank in an automated line by installing a drip tray or other collection or containment device between a process tank or rinse tank, such that liquid is collected and does not fall through the space between tanks. Valley Plating and the district dispute what is a spill that must be cleaned within an hour and what is a containment device. The rule does not explicitly define spill or containment device in its definition section, but its meaning can be derived from the use of those words in the rule. The evidence will show that the floor beneath the tanks is not a containment device. It is a pit and does not prevent liquid from falling between tanks. Spills within the pit may contain nickel and thus must be cleaned within an hour. The district will show 1, spills occur near nickel containing tanks, 2, the color of the spills indicate nickel, and 3, statements by Valley Plating's own personnel that the spills contain nickel. The district requests that the hearing board enter a condition that requires Valley Plating to clean spills beneath the tanks. And you can see that in attachment C, which is exhibit number 2. In addition, the parties dispute whether Valley Plating can walk or step on a containment device. One of the reasons for Rule 1426F is to prevent metal-containing fluids from dripping on walkways. Thus, the district contends that facilities are prohibited from using drip trays and containment devices as walkways. Valley Plating indicates that it walks on its drip trays to fix its line. The district had offered a middle ground during the period of the order of abatement. We had suggested a condition that requires Valley Plating to clean drip trays or containment devices on the line prior to stepping on them and provide a record of where and how often they do so. This information would have assisted in evaluating whether any claim that a device is a drip tray or containment device is misplaced. Valley Plating declined to stipulate to such a condition. Because this compromise condition was rejected, the district seeks a prohibition now against walking on drip trays or containment devices. No proposed findings and decisions has yet been prepared because the parties have been negotiating abatement order conditions to the 11th hour. As you can see, we have 2 documents, one with stipulated abatement order conditions and one that are conditions the district proposed. The district is prepared to file proposed findings and decisions after the hearing board has made a decision. Thank you.
Sir, Mr. Pomeroy.
Thank you, Mr. Chair. Brief opening. Many of the things that Ms. Sue stated are consistent with my understanding. We meaning Valley Plating, has worked diligently with the prosecution in their office to resolve through stipulation a number of the issues. Yet, as her piece of evidence number 2 suggests, we do have some ongoing concerns. In her in evidence piece number 1, there is a condition as you might have understood from the presentation you just heard. We have a fundamental disagreement of what 1426E3A means. We completely wish to comply. One of the reasons you as exhibits is so that you can see them and we can walk through them so you will be able to understand it. We've also taken photographs of all these alleged activities that are supposedly in non-compliance. I should, since we're talking about the history of how we got here, I've spent close to 12 months discussing this containment and spill issue with district. Until recently, the district's position was that all the containment devices that are on top of the line were also subject to the 1-hour spill rule, and that they would have to, that my client was going to have to clean the top of its line every hour while the operations were occurring. Now that position has been dropped, and we now have a new interpretation that's been rendered recently, that the containment device, i.e. the area underneath the tank, which is also part of an overall several containment devices on these lines, is somehow not a containment device. And so we have witnesses here today to testify with respect to this issue. One thing I should, and I think it's really important for you to understand, we are only talking about 1426 and we're only talking about nickel. There's no hexavalent chromium involved. The facility has ceased its hexavalent chromium operations. And in fact, what you have before you in the order of abatement is that the activities that were fully permitted for hexavalent chromium emissions have ceased. They ceased back in May of 2023. So you really have a facility that has reduced its overall toxic emissions. So what we're really focused on now and what remains is this question on nickel. One of the things that has been concerning to Valley Plating is the fact that nickel is only concentrated on a couple of its tanks. Most of the tanks, rather than what it states, but they've had counterflow rinse systems which are exempted under 1426 for regulation of, to determine concentrations. 1426 has basically a zero threshold requirement for metals. If you have a part per million of it, that subjects you to 1426 rules in general. Despite that, my issue and the issue that that Valley Plating has with all of this is the risk. Where is the emission? Where is the regulation needed here for what they're doing? They do regular cleaning of their containment pit according to the requirements under the rule, which required to be done weekly. They clean the top of their line daily. When they access the top of their tanks, they're doing so by spraying down the area, effectively cleaning it, approved cleaning method, and then walking onto the containment devices to move parts or adjust the conveyor. So and we're going to show you photos of that, and we're going to go through all that explanation. Overall, though, we still have a fundamental disagreement with the interpretation of district enforcement with regards to what is a spill and what is a containment device. And that's what we're here for today.
Chair, may I clarify something?
Yes, go right ahead.
Mr. Pomeroy had suggested that our stance has changed regarding the cleaning of drip trays. I don't want, I just want to point out in Rule 1469 G1A, the requirement for, there's a requirement that says for drip trays, they shall capture and return the liquids to the tanks. And that provision is different in Rule 1426. And as we have said, they have since drained their hexavalent chromium tank. Thank you.
Thank you.
Matt, a clarifying question.
Chairman,
Ms. Sue, I just wanted to note your conditions that they shall not walk or step on drip trays. That is not something that's now required by a rule in this case?
I will get into that via the evidence. There's not explicit statement that says they shall not walk or step on drip trays, but the purpose of drip trays is to prevent entrainment of particles via foot traffic or vehicle traffic.
Thank you.
all right, Ms. Sue, did you want to call your first witness?
Thank you. I'm going.
So before she begins her testimony, it will be done by noon. If not, then we'll probably pause for lunch and then come back. We cannot, we won't.
Alicia Lewis, Alisha, Lewis, Lewis.
Are you under oath? How long have you been a supervising air quality inspector?
Approximately 4 years.
And prior to that, what was your position, if any?
I was an air quality inspector.
And how long were you an air quality inspector prior to becoming a supervising air quality inspector? South Coast AQMD.
7 years and 4 months.
Okay, and how many plating facilities have you inspected during your time at the district?
Over 20.
And approximately how many were subject to Rule 1426?
Most, if not all.
Okay, and approximately how many were subject to Rule 1469?
Approximately half of those facilities.
Okay. Describe your educational and career background.
I hold a bachelor's of science in chemistry. I hold a master of philosophy in chemistry, and I hold a doctor of philosophy in chemistry.
And where did you get your doctorate from?
Syracuse University.
And what was your thesis, if any, for your PhD?
DNA remediated nanoparticle self-assembly.
Okay. And prior to working at South Coast AQMD, did you hold any other jobs?
Yes, I did.
And what was your job?
I was a staff research scientist at the University of Southern California.
Are you familiar with valley plating?
Yes, I am.
And have you inspected valley plating?
Yes, I have.
When did you first conduct an inspection at valley plating?
Believe it was June 2018.
And when was your last inspection at valley plating?
September 2024.
Okay, and approximately how many inspections have you conducted at valley plating from June 2018 to today?
Approximately 7.
Okay, and I'm going to get into some valley plating background. Please describe what valley plating does.
Valley plating is a facility that conducts plating.
Okay, and which city is valley plating located?
Okay. It's located in the city of Commerce.
Great, and I would like to put in another exhibit. So this would be exhibit number 4.
Record, this is exhibit number 4. There you go, sir. Exhibit 4. Overhead view of the neighborhood, Google Maps. Okay, Miss Sue, the floor is yours.
Referring to exhibit number 4, can you please describe what the exhibit shows?
The exhibit shows a Google Maps image of valley plating located on the bottom of the map and the surrounding community around valley plating.
And if Ms. McCune can hand you the cursor, can you use the cursor to point to where valley plating is? If Ms. Lewis can take your cursor briefly.
This is valley plating.
Okay. Is this a fair representation of the neighborhood?
Yes.
I would like to admit this document into evidence. Is it admitted into evidence?
Yes,
Great,
yes,
thank you.
yes. Yes, this is marked as exhibit 4.
Is how many feet are in a quarter mile?
1,320 feet.
And is there a white line in the middle of the image?
Yes, there is.
Please describe what it shows.
That is a utilizing the measurement tool on Google Maps. It is a measurement of the center of valley plating to a sensitive receptor, I guess showing that there are multiple sensitive receptors within 1,320 feet from the facility.
Thank you. And what plating lines does valley plating have?
Valley plating was permitted for a decorative chromium plating line and a strip line.
Okay. And what metals, if any, does valley plating use currently in its decorative chrome plating line?
I'm aware that valley plating utilizes nickel and trivalent chromium.
Okay. Are any of those metals, nickel or trivalent chromium, considered a toxic air contaminant?
Yes,
And which ones?
I believe both are considered toxic air contaminants.
Okay. Are there South Coast AQMD permits for those lines?
There were South Coast AQMD permits for those lines, and I believe the facility has since submitted applications to modify those.
Okay. And then we're going to mark the next exhibit. The next exhibit is exhibit 5. They're overhead representations of lines. We'd like to admit this into evidence. This was already stipulated too.
Okay. Just for the record, this is exhibit 5, for which has been stipulated to.
So looking at the first page on exhibit 5, can you read the top line in bold?
Sure, it says Valley Plating Decorative Chrome Plating Line 10/20/24.
And could you go to the next page? And what does it say in bold?
Strip line overhead diagram.
And going back to the first page, could you see, is there a number 27 there?
Yes.
And what does it say next to number 27?
Next to tank number 27, it says semi-bright nickel.
And what does it say next to 28?
Bright nickel.
Is it your understanding that tanks 27 and 28 contain nickel?
Yes.
Are you familiar with Rule 1426?
Yes.
Okay, now I'm going to hand out Rule 1426. Hold on.
Or you could stipulate, because I already have it in my exhibit as it's in its entirety, so you don't need to do it again. And I'll stipulate that it's the same thing if you're agreeable with that. Less paper.
Great, thank you. Referring you to Rule 1426A.
Mhm.
What is the purpose of Rule 1426?
The purpose of this rule is to reduce fugitive emissions from hexavalent chromium, nickel, cadmium, and lead at metal finishing facilities.
And currently, what metals on this list, if any, are you aware that Valley Plating uses in its operation?
Currently, nickel.
And who does the rule apply to?
The rule applies to an owner or operator of any metal finishing facility.
And how is metal finishing defined in the rule?
Metal finishing is defined in the rule under C18 on page 2 as metal finishing means anodizing, conversion coating, electroforming, electroless plating, electroplating, electropolishing, etch, passivation, pre-dip, sealing, or stripping by submerging the part into a tank or series of tanks with solution that contain a metal.
Does Valley Plating conduct any of these activities?
Yes.
And does the rule have specific provisions for automated and non-automated lines?
Yes.
And what type of decorative chrome plating line does the facility have, automated or non-automated?
The facility operates an automated line.
Thank you. And I'm going to pass out another exhibit.
Oh, yeah. Right here.
I would like to mark this as Exhibit 6 and put this into evidence.
It'll be accepted.
Please describe in basic, well, first of all, is this an accurate representation of part of the decorative chrome plating line that you've observed?
Yes, it is.
Okay, and please describe using this photo in basic terms how Valley Plating's automated line works. And if you would like, you can use the cursor that Ms. McCune has.
Okay. So the facility operates an automated line that moves in a circular process. From this photograph, parts are hung on this automated rack up here, and you can see the parts that are hanging from the automated rack on the top. And the parts are dipped into each of the tanks. The tanks are below. And the way that this particular automated line works is the parts would be coming towards you in the photo.
Great, thank you. Oh, we could take down the photo. Referring you to Rule 1426F, does Rule 1426F provide best management practices?
Yes, 1426F provides best management practice.
And then starting on page 5 of Rule 1426F, can you read F to F1?
Sure. F, best management practices. Beginning January 1st, 2023, an owner or operator of a metal finishing facility shall F1, minimize drag out from a process tank or rinse tank in an automated line by installing a drip tray or other collection or containment device between a process tank or rinse tank such that liquid is collected and does not fall through the space between the tanks.
Based on the rule language, what is the purpose of drip tray collection or other containment device?
To prevent liquid from spilling between the tanks.
Okay, and referring to page 6 of Rule 1426, what does Rule 1426 F3 state?
Sorry, can I go
Let's go ahead.
back? I just wanted to clarify, it should be falling between the tanks.
Thank you for that. And referring you to Rule 1426 F3, what does it state?
F3 states, if not treated as a waste, return all liquid collected pursuant to subparagraph F1 and F2 back to the tank.
Okay, and referring you to page 2 of the rule, what is the definition of process tank?
The definition of process tank pursuant to C22 of the rule means any tank used for metal finishing with a tank solution that contains a metal.
And remaining on page 2, what is the definition of metal?
Metal means hexavalent chromium, nickel, cadmium, or lead.
And now referring you to page 3 of Rule 1426, what is the definition of rinse tank?
Rinse tank is defined under C23 as any tank, means any tank where a part is partially or fully submerged into a liquid to remove any residual solution from a process tank.
Okay, now I'm going to hand everyone a staff report. Number 7, Cindy. Oh, wait. Oh. Wait until she starts. Wait until everyone. I'm handing you what's labeled as the final staff report for proposed amended Rule 1426 and proposed amended Rule 1469. I'd like to mark this as Exhibit 7 and admit this into evidence.
Yes, it'll be accepted.
I refer you to page 30. If you could please turn to page 30.
Yes.
And do you see on the bottom, there's a header that reads drip trays, collection devices, or containment devices F1, F2, and F3?
Yes.
Could you please read aloud the last 2 paragraphs?
Paragraph F1 and F2 require owner or operators to install and use drip trays, collection devices, or containment devices for automated or manual process lines. An automated line has tanks that are in a sequence where parts and equipment are submerged into a tank with an automated hoist. Drip trays, collection devices, and containment devices are designed to prevent drag out. Drag out is the fluid that drips from parts or equipment as it is removed from a process tank and is not collected or returned to the tank or separate rinse tank. Instead, the solution ends up on surfaces such as the tank lips or walkways. These tank solutions can be carried out of the facility through vehicle or foot traffic, or dried out and could be carried through cross drafts. Paragraph F3 requires collected tank solution to be returned to the tank unless the tank solution is treated as a waste or a spill. Staff has observed during the development of PAR 1426 and the most recent amendment to Rule 1469 in 2018 that drip trays are placed between tanks to prevent the tank solution from landing on surfaces. The drip trays return the collected tank solutions to the tanks.
Based on what you just read, what are the concerns that Rule 1426 F1, 2, and 3 address?
This section aims to prevent drag out from the tanks, prevents those drag outs from then being dried and carried through vehicular or foot traffic, and then also attempts to prevent solutions from landing on surfaces.
And returning to Rule 1426 F, best management practices. Can you take a moment to review F? Is drip tray or other collection or containment device used anywhere else in Rule 1426 F other than F1 and F2? So please take your time and review carefully.
Other than which sections? F1 and F2?
Other than F1 and F2, is drip tray collection device or containment device used anywhere else?
I do not see that it's used anywhere else.
Okay, I will be handing out another exhibit. What number are we on? What? What number are we on? 9? Change the number. Are we 8? The new one. Okay. I'm handing out a document labeled containment device examples. I would like to mark this as Exhibit 8.
It is hereby marked and accepted as Exhibit A.
Okay. Could you please describe, Ms. Lewis, what is in the top photograph?
The top photograph is an example of a drip tray or containment device where the facility has two tanks, the tank on the left and the tank on the right. And the device that is installed is slanted so that liquid flows back into the tank on the left. So it does not fall in between the space between the tanks on the right and left.
And would it be helpful to use the cursor to explain what you just said?
So this is the what was installed in this particular facility. There is a tank over here on the left-hand side. There's another tank here on the right-hand side. The this drip tray or containment device was installed to prevent the liquid from falling between the cracks or the spaces between the tanks.
Thank you. And could you please describe what we're seeing in the photograph below?
This is another example of a facility that has two tanks. So this one has a tank up here in the middle of the photo, and then a tank over here to the right of the photo. This particular facility installed more of like a beveled containment device or drip tray, and the solution flows back into either tank, whereas the other example flowed in one direction.
Are these accurate representations of examples of containment devices?
Correct. These are examples of containment devices.
Okay, and according to Rule 1426, for Rule 1426 containment devices, does the liquid have to be returned to the tank? You could refer back to the
Yeah, I
rule if
would
you
like
need
to refer
to.
back to the rule really quick.
I believe it's 1426 F3.
If it's not being treated as a waste, the liquid shall be returned to the tank.
Okay. Are there containment devices not shown in this exhibit that would be allowed under Rule 1426?
Yes.
What are the key features of a containment device under Rule 1426?
The key features of a containment device is installed such that liquid is collected and does not fall through the spaces between the tanks.
Thank you. And I'm going to refer you to page 4 of Rule 1426E. Does Rule 1426E provide housekeeping requirements?
Yes, it does.
And please read aloud 1426E3A.
E3 through E3A or just E3A?
Just E3A.
Okay. E3A on page 5 of the rule talks about cleaning using an approved cleaning method, and A specifically says any liquid or solid material that may contain a metal that is spilled no later than 1 hour after being spilled onto a solid surface, except if spilled in a drip tray or containment device.
So does the material have to contain metal to be subject to this cleanup provision?
No.
Please remind us, how is metal defined in the rule?
Metal defined in the rule as hexavalent chromium, nickel, cadmium, or lead.
Thank you. Is spill defined in Rule 1426C?
No, it is not.
In your experience, what are the defining features of a spill that must be cleaned within an hour?
The defining features of a spill that must be cleaned within an hour is going to be liquid or solid material that is not contained.
Have you discussed the meaning of the term spill with valley plating on-site personnel?
Yes, I have.
Who have you discussed this with?
Rosalino Hernandez, Jose Pineda, Dave Cullen, and the facilities consultant at the time. I believe his name is Oscar.
How many conversations have you had with them regarding spills?
Approximately 5.
Okay. And did you discuss with them what is a spill?
Yes.
And what did you say to them?
We discussed a particular area where a spill was observed, and I indicated to them the provisions of Rule 1426 that if there is a spill, and that spill may contain a metal, that it does need to be cleaned up within 1 hour.
Did anyone respond to your comment?
Yes.
Who responded?
Jose Pineda,
And what did Mr. Pineda say?
that he understood and that he would see if that constituted a spill.
Have you provided them with on-site personnel a copy of the rule?
Yes, I have.
Referring you to page 5, does Rule 1426E3B provide any requirement regarding cleaning walkways? Page 5E3B.
Rule 1426E3B talks about, I'm sorry, what was your question?
And what is the requirement in E3B?
Okay. Surfaces within the enclosed storage area, open floor area, walkways around the process tank, walkways around the rinse tank, and any dust accumulating surface potentially contaminated with metal on a weekly basis.
Okay. And referring you to E3C, what is the requirement, if any, for cleaning splash guards, drip trays, collection, or containment devices?
Splash guards, drip trays, collection devices, or containment devices on a weekly basis. Sorry, the facility is required pursuant to E3 to clean using an approved method, and then E3C says those particular provisions.
Thank you. And referring you to pages 5 and 6, looking at housekeeping provisions. If Rule 1426E are housekeeping provisions, correct?
Rule 1426E is housekeeping provisions, yes.
Is there any requirement for cleaning drip trays, collection devices, or containment devices before walking or stepping on them?
No.
Okay. And I have some photographs to share. Cindy, what number are we on? What number? 9. I'm handing you documents with a header of June 7th, 2024, which we are marking as Exhibit 9. I would seek to admit this into evidence.
Your request is hereby granted. This will be Exhibit 9.
Ms. Lewis, did
Yes.
and do these photos accurately represent what you observed at Valley Plating on that date? Take your
Yes.
time to look at the photographs you need to.
Oh, man.
Yeah.
Yes.
Thank you. On this first page of the exhibit, page 1 of 3, can you describe in brief terms what this photo shows? Please use the cursor if you would like to.
Okay. This photograph shows Valley Plating's tanks in the back. These brown this brown color here, that is the facility's tanks. And you can see at the top of the photo, there are parts that are hanging on that automated line. So this is kind of on the bottom floor, I guess, of the facility's plating operation. Before, when the photograph was taken, when the parts were coming towards us, we were standing on this grate that is up on a elevated surface or elevated platform. Again, this is the automated system up here, the parts that are hanging, and then this is the magnitude, I guess, or the volume of their tanks. It's approximately about 10 feet in height.
Thank you. And turning to page 2 of this exhibit. Approximately what time was this photograph taken?
Approximately 10:40.
Okay. And where was
AM.
where was this photograph taken?
This photograph was taken at Valley Plating on the flooring in the pit near tanks, around tanks 27 and 28.
Can you point out to where the tanks are using the cursor?
So these would be like the tanks in this
Okay,
area.
thank you. Would you consider this floor a drip tray collection device or containment device as defined in as used in Rule 1426C?
No, I would not.
And why not?
Because the provisions of Rule 1426, the containment devices are supposed to limit, or I can just refer back just to get the right terminology. Are supposed to minimize drag out from the from the rinse tank or process tank, so that it does not fall between the spaces between the tank.
Okay, do you see a pipe in the photograph?
Yes, I do.
Okay, and looking at the area below the pipe, can you describe what you see?
The area below the pipe.
Mhm.
So this area below the pipe is the flooring in this was the floor essentially. And this color of material that is on the floor is powdery material that is consistent with the colors observed of solution in tanks 27 and 28.
Okay. Did you take a sample of this powdery substance?
No, I did not.
What do you believe that it is?
I believe that it is dried material from the tanks, nickel plating tanks.
Okay, and why do you have that belief?
The color of the material is consistent with the color of the material in tanks 27 and 28. Additionally, I was with the facility personnel and I asked them what this is, and they indicated likely nickel.
And who did you speak to?
Jose Pineda.
Okay. Did you ask him about when this would be cleaned?
Yes, I did.
And what did Mr. Pineda say?
He said within a week.
Okay. Did you ask him how long it's been there?
Yes, I did.
And what did he say?
He was not sure.
Okay. Do you see a hose in this photograph?
Yes, I do.
And where is it?
The hose is on the right-hand side of the photograph.
Okay. What, if anything, is underneath the hose on the right-hand side of the photograph?
Under the right-hand side of the photograph is material, specifically liquid, that appears to resemble the same color of the material in tanks 27 and 28.
Okay. What would happen if someone moved the hose?
That material that is on the hose would be potentially moved to wherever the hose was moved.
Okay. Referring you to page 5 of Rule 1426. Looking at 1426E3A. Do you, go
Excuse
ahead.
me, Ms. Sue, what page are you on? Just-
Page 5 of Rule 1426.
Thank you.
Do you believe Rule 1426E3A requires that this dried material be cleaned within an hour?
Yes, I do.
Thank you.
Were we recording or did it stop?
For just a little bit, but then start it up again.
Okay, very well. So why don't we go ahead and we can break for lunch at noon. What are you thinking, 30, 45?
45.
45, and we have two more, you have actually three more witnesses.
No, we actually only have one more
One
witness.
more, and then Mr. Pomeroy, you have how many witnesses?
Three.
Three, very well, and then there'll probably be some cross.
Oh, I'm obviously gonna have to cross on some.
Okay, very well. So why don't we go and take 45? So we'll break now at noon. We're back at 12:45 and we're off the record.
Thank you.
on the record at 12:50 PM. Just had a couple questions. Back on the record at 12:50 PM, just had a couple questions. Ms. Sue, how long do you believe the witness will be?
For this witness, maybe another 10 minutes, if that?
And then there's cross. Okay. And then your second witness, this is your only witness.
We have Mr. Vergara, another inspector.
Okay, and then how many minutes with that person, roughly?
I would say maybe half the time that I took
Okay.
with Ms. Lewis.
So about 15, 20 minutes, and then we have 3 on your side, and then there'll be,
I'm going to help you out a little bit. I think we can dispense with one of my witnesses. There was a number of basic establishing things that were provided by Ms. Sue, so I will cut it down to 2 witnesses.
okay, and there is a stipulated agreement for which you've agreed to, correct?
The stipulated facts and conditions.
Oh, yes, I've agreed to the stipulated facts.
Okay.
Oh, yeah, that's absolutely correct.
Okay, so just so we can kind of help this along,
All right.
any sore spots of contention around what's not stipulated. Again, I don't want to tell you how to try your case, but if we already have agreement on the bulk, then the disagreement will fall around these concerns that are documented in attachment C,
Yes.
which is a district exhibit. That's district exhibit, just for the record here. 2, district exhibit 2. So again, if we can help to frame and then construct around that, it would help us as far as time is concerned as well as efficiency. So without any further ado, I'll be quiet and turn the floor back over to Ms. Sue.
Thank you, Chair Ollie. Ms. Lewis, can you turn to page 3 of the exhibit that you had before you, which was, do you recall the last exhibit we were on? I believe that was exhibit 9.
Yes, I have it.
Okay, could you turn to page 3 of that exhibit? I'll give a moment for Ms. McCune to pull that up. About what time was this photograph taken?
Approximately 10:40-ish.
Okay. And that's 10:40 a.m.
AM, sorry.
Okay. And where is this photo taken?
This photograph was taken in the at valley plating in the areas near tanks 27 and 28 on the floor of the facilities pit.
Okay. And do you consider this floor area a drip tray collection or containment device as used in Rule 1426?
No, I do not.
Why not?
Because in Rule 1426, it limits the potential drag out from these tanks from falling in between the spaces between the tanks.
Okay, is there liquid in this photograph?
Yes, there is.
Can you describe where this liquid is?
Sorry, can you repeat the question?
And could you describe where the liquid is in this photograph?
The liquid is located kind of starting in the center of the photograph and kind of it's like an oval area in this air pit.
Okay. And what color is this liquid?
It's a greenish blue.
And what do you believe it is?
Believe it is a solution from the nickel tank.
Okay, and did you take a sample?
I did not.
Then why do you believe it's solution from the nickel tanks?
It is in the general area of the nickel tanks. Additionally, I was with facility personnel, and when I asked about this particular area specifically, I asked, "What is this?" And they stated that it was likely nickel.
And who did you speak to?
Jose Pineda.
Okay, and does the color of the liquid tell you anything?
Yes, the color of the liquid appears to resemble the color of the liquid in tanks 27 and 28.
Okay. And can you describe your conversation with Mr. Pineda?
I asked Mr. Pineda specifically about what this was. Mr. Pineda stated that this was likely nickel. I asked when is the area cleaned? And he stated as needed. And then I said, when will this area be cleaned? And he said within a week or more. And I also asked him, I didn't ask him. I also referred to him that if this is a spill, that it needed to be cleaned up within 1 hour. And he did state that he understood what I was saying.
Okay. Is there a black bucket in this photograph?
Yes, there is.
And do you know what this bucket was used for?
The facility stated that there was maintenance at the tank, and that bucket was used to help with maintenance on one of the tanks.
Okay. Is there a hose in this photograph?
Yes, there is.
And what is under the hose?
The liquid, there is a greenish blue liquid, similarly resembling contents from tanks 27 and 28.
And what would happen if someone moved this hose?
Liquid that potentially may contain a metal would be moved to other locations outside of where it currently is.
Okay. And referring you to Rule 1426 on page 5. So Rule 1426 E3A, do you believe this greenish liquid is required to be cleaned within 1 hour?
Yes, I do.
Okay. At the end of your inspection in June, did you have a conversation with on-site personnel about your observation?
Yes, we did.
And so what time was the end of your inspection approximately?
I don't recall exactly how long after, but it was approximately maybe an hour or so after.
Okay. And who did you have the conversation with?
I don't recall everybody who was there, but I do know that Jose Pineda was there, and I do know Rosalina Hernandez was there.
Okay. Did you have a conversation about your observations?
Yes, I did.
And what did Mr. Pineda say regarding your observation?
I reminded the facility that if there is a spill of any liquid or solid material that may contain a metal, it's required to be cleaned up within an hour. And the facility stated that they understood that provision.
Thank you. At this time, I am done with my direct with Ms. Lewis.
On cross?
Thank you. Boy, a lot of things to go through here, but I'll try to keep it as simple as possible. And I would appreciate if we can pull a couple of things up on screen. You have exhibit number 5, which is the chrome plating line. This is just so I understand the testimony of the witness. And Ms. Lewis, this is the exhibit number 5, which has the chrome plating line up here. Are all these tanks subject to 1426?
No, all the tanks are not subject to 1426.
Which ones would not be subject to 1426?
There are a number of tanks that may not be subject to 1426.
And for what reason is that?
There could be a number of reasons that a particular tank may not be subject to 1426.
There's only one reason, which would be that it doesn't contain metal. So are you saying that certain tanks don't contain metal on this line?
There are some tanks that don't contain metal, but I do not agree that that's the only reason that a tank would not be subject to
Okay,
1426.
yeah, I won't go through and parse through 1426 with you, but is there a certain point in the line that 1426 applies?
Yes.
At what point is that?
1426 applies to facilities that, conduct metal finishing. And within the rule, there is a specific section of the rule talking about tank process area. So it can include areas surrounding tanks that contain metal.
If a tank does not contain nickel, and nickel is the only metal that makes it subject to 1426, is that tank regulated by 1426?
Yes, it could be regulated by 1426.
Despite the fact that it does not contain one of the metals?
That's correct, because it could be subject to the tank process area.
Boy. To go.
Which is an area surrounding a process tank or rinse tank that is within 15 feet.
Okay, all right. I disagree, but we'll keep rolling. Okay, so I want to try to understand a little bit about some of the definitions and interpretations is there a definition in 1426 for spills?
No, there is not.
Is there a definition for containment?
No, there is not.
Is there a definition for containment device?
No, there is not.
Is there a definition for splash guard?
I need to double check if I can just refresh. No, there is not.
Is there a definition for waste?
No, there is not.
I guess now that we don't have any definitions to work with, I'm trying to understand exactly what you were referring to as far as how you've interpreted the regulations. So I seem to understand that you are working and you've cited to 1426 F1 of the rule, which talks about minimizing drag out. Now, can you just read, I think the most important clause is the last handful of words that it suggests that the process is supposed to do something. And can you just read the last, because it is a whole thing. I either have to read the whole thing or at least read the end of it, such that liquid is collected and does not fall through the space between the tanks. Are you suggesting that the only place that a containment device complying with 1426 occurs is the exact two edges of the process tank so that drag out doesn't fall between them?
I'm sorry, can you repeat the question?
Yes. Under 1426 F1, it states that you need a containment device so that liquid doesn't fall through the space between tanks. Are the two edges of the tanks the only place where containment devices, by your interpretation, are allowed?
I guess no, because they are allowed to be installed in other areas.
I'm reading the rule and I'm just trying to understand, because the term by your own testimony is that a containment device is only for this particular aspect, and it's nowhere else in the rule, as you testified. So if that's the case, isn't it limited to the area, the space between the tanks?
Yes, the facility can utilize a drip tray specifically in that area to collect so that it doesn't fall between the spaces of the tanks.
Right. So nowhere else would a containment device be acceptable under 1426?
I think the I think containment. I think I would have to see if there potentially may be another way in which a facility may be using a containment device.
Beyond a space between the tanks?
So specifically in F1, it is to prevent liquid from falling between the space between the tanks.
So are you suggesting by your testimony now that there are other areas where containment devices could be installed?
Possibly.
Where would that be?
I cannot think of another example at this moment in time.
Okay, I'll expand upon it a little bit differently. If we have a containment device such as a containment pit, if we have other forms of capture and control of liquids around the line, let's say we have capture devices on the other sides of the tank, not the two edges that the drag out goes on, but actually capture on the other sides of the tank. Would those various forms be considered containment devices? Or would they be deemed spills if they had any liquid in them and have to be cleaned within 1 hour?
If you have a specific photograph, that would be helpful. This is because now you're asking about the whole universe of possible.
It's a
Devices.
relatively simple question. Are there other containment devices that are capable, including a containment pit, that could be identified as a containment device and not subject to the 1 hour cleanup rule? Containment devices are, I don't want to pontificate about it, but a containment device captures liquid so that it doesn't travel, it isn't carried across where people are walking on it,
Objection,
et cetera.
you're testifying.
Overruled. What? No, well,
Yeah, I'm trying to get a clear answer as what is a containment device that is now subject to this interpretation that's been created since there's no rule definition of this term, and I'm not getting a straight answer. That's my concern.
so we'll sustain the objection, and we'll allow you to continue on, sir.
All right. Well, that's the thing. I'm just trying to, I want to understand if a containment pit could be deemed a containment device that isn't subject to the 1 hour rule.
A containment pit would not comply with the provisions of F1.
Because it is what? In your
Because-
view, in your view.
Because one, it's not installed on the process tank or rinse tank such that liquid is collected and does not fall through the spaces between the tanks.
There's no requirement for the actual installation of the containment device on the tank itself. I'm not seeing that in the rule. So you're saying now it has to be installed on the tank?
So it's installed between the process tank or rinse tank.
Okay.
as we,
And you think there's possibility that collection devices could be used in other areas besides between the tanks? You just don't know of any. You can't think of an example.
I cannot think of an example.
Okay. All right. So, maybe we can go to one of the photographs just to help out a little bit. I think if I can find the right photo for you, it is, he had all kinds of lovely photos. I think it's in your, yes, your exhibit 9. Just exhibit 9, the first photograph. You identified the structures sort of in the bottom middle that are brown and sort of square and rectangular forms on them as the tanks. What is the area below that?
Another floor where I believe the facility calls that the pit.
Okay, and how, do you know the depth of that pit?
I do not.
Do you know whether there is foot traffic or any kind of vehicle traffic going through there?
Yes.
There's vehicle traffic going, or foot traffic, yes, through there. What is that vehicle or foot traffic?
When I asked the facility specifically how they clean in that area, they stated that they walk in that area.
So to maintain a containment device, they clean it by entering it to clean it. Is that correct? I'm just trying to make sure.
Objection, she did not use the word containment device.
Objections overruled.
Okay. Oh, I'm just trying to understand. So for maintenance purposes, they're in there that when they clean it.
The facility stated that they go into this area and walk when they clean the area.
Okay, that's great, great. Is there any information about cross drafts in that area?
What do you mean by information?
Do you know, do you have any knowledge about cross drafts down in that area, the containment pit?
No.
Objection mischaracterizes the witness testimony. She does not call it a containment device.
I stated a containment pit. So,
Objections
all right.
She did not call it a containment pit.
Actually, she did, so I'm sorry.
Yeah, objections overruled.
Thank you.
I do want to hear this now. I
Yeah.
want to understand.
I
what
am
is it
trying,
doing.
I'm trying to
My
understand.
apologies if I misremembered.
Yeah, no, she called it a pit.
She did.
Yes.
That's why I'm trying to get to the point. So maybe I can refer you back to your exhibit 7 and look at the page 30 that was brought up. And I note in the first paragraph, can you read the last sentence of the paragraph on page 30, exhibit 7?
Thank you.
It is the paragraph immediately following drip trays, collection devices, or containment devices at the bottom. There's 2 paragraphs at the bottom of page 30, and it's the next to last one, and just the last sentence.
So just to be clear, Counselor, this is the same section she referenced. Just want to be.
Correct. I'm not delving into other areas. I'm trying to cross based on what she originally testified to. So I'm just trying to understand and have her review and state the last sentence of the first paragraph. And then we'll go from there.
Okay. The last sentence of the first paragraph states, these tank solutions can be carried out of the facility through vehicle or foot traffic or dried out and be carried out through cross drafts.
So do you have sufficient information to believe that the containment pit does any of those actions or creates any of those actions that would in fact create the risk that is identified in this paragraph.
Yes.
Can you elaborate a little bit on what you believe to be the case?
The facility has stated that they walk in that area specifically.
For maintenance purposes?
They stated to conduct cleaning.
Okay, that's fine. Thank you. All right, well, I'm trying to be mindful of the time and everything here. And I think my witnesses will be able to respond and take care of much of the other stuff to take care of it. So appreciate everything, and I'm finishing my cross. Thank you.
Thank you. All right, members of the board? Oh, I'm sorry. No, she didn't seek any request for redirect. Members of the board?
I don't have any redirect at this time. Thank you.
All right, I'll let Mr. Pittman, Ms. Verdugo Peralta.
Thank you, Mr. Chair. Ms. Lewis, so in totality, what you're really telling us there that there is material that the employees walk on and that they're tracking it in and out of that area. Is that what you're stating?
Correct.
Basically, after all of this. And so is that the only location where that is occurring, or is it occurring throughout the facility?
It is occurring at other locations other than what we've discussed
Just
throughout the
there.
facility.
Okay. So is it also getting on the clothing and shoes, I would suspect, of the employees who work there?
I don't know for certain, but based off the fact that the facility states that they walk in that area where there is material that has been dried or material that is wet, like in that photograph, I would believe it to be that the facility would get it on their shoes.
Do you know if there is any protocol for them to either be able to remove the contaminant and or my concern here is their health risk as well, not just the surrounding neighborhood, but also the employees. And do you know if there's any type of protocol that they have if they are exposed to this toxic, if there's any protocol at all?
I'm not aware if there's a protocol.
Okay, thank you.
Any other members of the board? Mr. Pearman?
So I just want to be clear, there is no definition of drip tray, correct?
That is correct.
And for purposes of these rules we've been talking about, there is no definition of collection device,
That's correct.
and there's no definition of containment device.
That is correct.
Now, there's been much talk about the fact of some escape of the liquid at the ends of the tank. But I'm just thinking a tank of liquid, isn't it possible that there could be some sort of overflow and liquid could go over the sides of the tank? Or is that impossible in this situation?
That is possible.
Well, from the district standpoint, wouldn't you want to contain that somehow, just like you would liquid that escaped at the end?
I believe the district would.
So you'd have to have a containment device to do that.
That is correct.
So, all right, thank you. Nothing further.
Any additional questions? Balaka Palau?
Yes. So do plating shops have containment for spills?
Can you specify
You've been to,
containment?
as you have testified,
Mhm.
numerous plating shops.
Yes.
Do you see containment, concrete containments under the tanks to tank, if there's an accidental spill or spillage or whatever, to contain the spill?
No, I have not looked at that in specific other areas, because our rule does not address that underneath the tanks. But yes, I have seen the structure that you're describing at other facilities. But it's not something that I typically look at because our rule does not specifically address it.
But typically, they will have containment for the spill under the tanks, so that if there's an accidental or they didn't minimize the spill and there's spillage from moving from one section of the tank to the rinse tank or whatever, there's a secondary containment basically. If I use the tank as a primary containment, the rinse tank, there's secondary containment so that it does not go down into the groundwater or contaminate the soil. Are you familiar with that type of containment, secondary containment?
Like I said, I haven't reviewed that specifically at facilities. Yes, there are structures that exist, like you're mentioning, that are concrete structures that I do see at facilities, but I won't say never, but I don't typically inspect that or look at that area.
Sure, but it does not preclude a facility from having that, right? A containment area for spills.
Did you say, does the rule
No, forget the rule.
Oh, okay. I'm sorry. I missed the first thing that you
Yeah,
said.
no, preclude, I meant. But
Preclude,
okay,
okay.
let's move on. I just want to also clarify the drag out, the definition of drag out. If you look at the staff report that was referenced, and if you can look at, what it says drag out in the first paragraph, page 30.
Yes.
If you don't mind reading the third sentence, what drag out is.
In the middle of that paragraph, correct?
Yeah.
Okay. Drag out is the fluid that drips from parts or equipment as it is removed from a process tank and is not collected or returned to the tank or a separate rinse tank.
So when it goes from the nickel plating, right? Then it goes to what does it go next to after that?
Depending on which tank you're talking
Let's
about.
look at
but
this. Let's look at the
possibly a rinse tank.
this drawing you gave us,
Uh-huh.
exhibit. Where is that? 5, is it? Which has the line drawing. Where 36. What is that? Tank numbers 36, 37. Hold on, let me get that. Yeah, 27 and 28.
Mhm.
What is after 28?
Bright NI drag out.
So nickel drag out.
Nickel
So
drag out.
bright nickel drag out. Series of rinse tank to capture any metal, any residue on the parts or anything that is dripping still, correct?
Correct.
So if the definition, if it's going into, it's removed from a process, not collected or returned to the tank or separate rinse tank. So it is going to separate rinse tank, correct? The drag out has been collected in separate rinse tank.
Some of the drag out.
Some of the drag out.
Mhm.
And the rule says, doesn't assume you're going to have no, it just says to minimize, correct? Because there will probably, like you said, there will be some that are still maybe on the parts or something that might not completely come out in the rinse tank, right?
Correct.
Just like a washer or whatever, okay. So, so then coming back to the rule, basically, which says minimize drag out. So that, because the drag out says it doesn't apply if you go to a rinse tank. So does this apply? I'm not trying to put you on the spot. I'm just asking because I just happen to, see that. So it says minimize drag out, but drag out, it's not considered drag out if it goes into a rinse tank.
I would disagree with that because there actually is a definition of drag out in the rule.
Okay, let's look at that drag out definition.
Sure.
And what does it say there?
Drag out means, would you like me to read it?
Yes, he would.
Okay, thank you. Drag out means fluid containing hexavalent chromium, nickel, cadmium, or lead that drips from parts or equipment used to remove those parts from a process tank or rinse tank.
Okay, so you're saying because it says all rinse tank, anything that comes out from the rinse tank is a drag out?
Possibly.
So it sort of contradicts what the staff report says, in a sense, right? Because it says it's not drag out if it goes into a rinse tank. I'm just trying to understand why one says one thing and maybe reading too much into it. What's your opinion on that? I mean, I think you're correct. When you said you pointed out to the definition of drag out and it indicates rinse tank. So that's what you're saying. It's a
Right,
rinse tank, and I think coming from the rinse tank is considered drag out. And
correct.
so you're saying the housekeeping provision applies because it relates to drag out.
Correct.
Okay, except I think Mr. Pomeroy's point, and I am sure he has witnessed, maybe can clarify that, except if it's if it spills into a containment device. And your contention is that that area under the tank is not a containment device.
That is correct.
Okay, I want to understand. Thank you, I appreciate it.
You're welcome.
Any additional questions from members of the board? All right, Ms. Sue, your next witness. And if possible, I know we said it this earlier, but if we can try to find some common ground as far as exhibit 2, hopefully we don't get too stuck in the pit, no pun intended. But if we really can delve into these disputed areas, because we seem to have agreement everywhere else with the exception of a few areas. And I do understand you have to put your case on. I do respect that. I do respect it immensely.
We just handed out photographs that have the header February 18th, 2025. We would like to mark this as Exhibit 10 and admit it into evidence. Thank you.
Excuse me, just for the record, my microphone was off. The exhibit has been marked as 10 and accepted.
Mr. Bergara, please state and spell your name for the record.
Hello, my name is Gerardo Vergara. Spelling is Gerardo, last name Vergara, Vergara.
Okay, and what, are you under oath today?
Yes, I am.
And what is your position at the district?
I am an air quality inspector for the Toxics Waste and Management Division.
And how long have you been an inspector?
Approximately 7.5 years.
Okay, and how many years have you been part of the toxics team?
All 7.
Okay, and how many plating facilities do you inspect each quarter during your time at the district?
Approximately 5 to 6 per quarter.
Great. Please describe your educational and career background.
I hold a Bachelor's of Science of Environmental Science from the University of California, Riverside.
Okay, and prior to working at the district, have you worked anywhere else?
Yes, I used to be a research scientist for the USDA laboratory, as well as chemist for a environmental science laboratory. Oh. Hello.
Yeah, you may want to go back and.
Okay, but please state and spell your name for the record.
Apologies. Gerardo Vergara, spelling Gerardo. Last name Vergara, V as in Victor, Ergara.
Do we need to repeat any of the other testimony?
Yes, because I'm very confident it wasn't captured.
So yes, we should do this. Okay, are you under oath today?
Yes, I am.
And what is your position at the district?
I am an air quality inspector for the Toxics Waste and Management Division. Three,
And how long have you been an inspector?
approximately 7.5 years.
And what team were you a part of?
I've been a part of the Toxics Waste and Management Division.
Okay, and how many plating facilities do you inspect each quarter during your time at the district?
Approximately 5 to 6 plating facilities every quarter.
Okay, describe your educational and career background.
I possess a Bachelor's of Science of Environmental Science from the University of California, Riverside.
Okay, and prior to working at the district, did you work anywhere else?
Yes, I used to work as a research scientist for the USDA Salinity Laboratory, as well as a chemist for an environmental science laboratory.
Okay. Are you familiar with valley plating?
Yes, I am.
Have you inspected valley plating?
Yes.
And when did you first conduct an inspection at valley plating?
2004, January.
And when was your last, sorry, go ahead.
January or February of 2024 was my first inspection.
And when was your last inspection at valley plating?
February 18, 2025.
Okay. And approximately how many times have you been at the facility since February 2024?
Approximately 4 to 5 times.
Okay. Are you familiar with Rule 1426?
Yes, I am.
And if you could refer to the rule. That's the staff report. Is there not a copy of the rule up there? Oh, great, Mark. Thank you.
Awesome.
Referring you to page 5 of the rule. Looking at 1426E3, what is the requirement?
Under this requirement, 14E3A states that any liquid or solid material that may contain a metal that is spilled no later than 1 hour after being spilled into a solid surface, except if spilled in a drip tray or containment device.
Okay, and referring you to page 6 of Rule 1426. Looking at F1, what is the requirement regarding drip trays or containment devices?
The requirement is to minimize drag out from a process tank or rinse tank in an automated line by installing a drip tray or other collection or containment device between process tank or rinse tank such that a liquid is collected and does not fall through the space between tanks.
Okay, and you have in front of you Exhibit 10, some photographs.
That is correct.
Can you take a moment to take a look through those? I think there's 4 pages total. Were you at the facility on February 18th, 2025?
Yes, I was.
Are these photos an accurate representation of what you observed that day?
Yes, they are.
And approximately what time were these photographs taken?
These photographs were approximately taken at 12:30.
Okay. And let's look at the first page of Exhibit 10. Where was this photograph taken?
This photograph was taken of their pit floor area.
Okay, and what tanks, if any, is this near?
This photograph was taken near their nickel tanks.
Do you consider this pit area underneath the tanks a drip tray or collection device or containment device as used in the rule?
No, I do not.
And why not?
Containment device, as interpreted, is to prevent any drip or leaks that fall in between tanks.
Okay, is there liquid in this photograph?
There is.
And where is this in the photograph? And please use both your words and the cursor to describe what you're pointing to.
If we focus, the focus of the area would be in the center section of the photograph towards the bottom. We can see ponding of liquid.
Okay. And what color is this liquid?
It has a green bluish hint to it.
Okay. And what do you believe this is?
I believe this is a nickel-based solution.
And what leads you to that belief?
The operations supervisor on site stated that this was a nickel-based solution spill.
Okay, and does the color provide information as to what this material is?
Yes, the color does look very similar, if not the same, from the tank observed above it.
Okay, and did you take a sample?
No, I did not.
Okay. So you said you had a conversation with on-site personnel, and could you describe that conversation?
On-site personnel escorted me on February 18th through the pit. After discovering these spills, I asked the supervisor what they were. The supervisor, Mr. Jose Pineda, stated that they were nickel-based solution spills in the pit.
Did Mr. Pineda say when this liquid would be removed?
No, he did not.
Okay. And referring you to page 5 of Rule 1426. That's 1426 E3A. Do you believe that this liquid needs to be cleaned within 1 hour?
I do.
Okay, thank you. And to the next photograph on page 2 of Exhibit 10. And where was this photograph taken?
This photograph was taken in the pit area as well.
And what tanks is it near?
This is also near some nickel tanks.
And do you consider this pit area a drip tray, collection device, or containment device as used in Rule 1426?
I do not.
And why not?
Because based on the rule, it is not there to capture any drips and or leaks that are falling in between the tanks.
Okay. And please describe the texture of the surface of these floors.
The surface of the floors do appear to have cracks, crevices, and is not a smooth surface.
So does this pit area, in your opinion, would it prevent air emissions of nickel-based solution?
No.
Okay. And as I stated in my opening statement, I'm not going to get into what are in the buckets or what the buckets are used for, because we're still evaluating that. That may be a question for another day. Referring you to next pages 3 and 4 of Exhibit 10. Did on-site personnel explain to you what this document is?
Yes, they did.
And who explained to you what this is?
The ones that explained this to me were on-site staff that consisted of Jose Pineda and Rosalino Hernandez.
Okay, and what did they say this document was?
This was their housekeeping log demonstrating that the pit does get clean on a daily basis
Okay,
after their shift.
referring you to page 4 because it's an easier place to read. Please read it loud, the top of page, starting with Valley Plating Works Incorporated.
Valley Plating Works Incorporated, LA County Sanitation District's Industrial Wastewater Discharge Permit number 14391. This document states
Keep going.
Oh.
Go ahead.
State Spill Containment Area Materials Handling Log. To comply with our wastewater discharge permit, all materials that enter a spill containment area must be treated as a spill, including rainwater and any processed or wastewater that result from normal operations. All materials removed from the spill containment area, whether hazardous or non-hazardous, must be included in this book.
Thank you. And could you please read aloud the headers for the columns?
Date, time, description of material, volume, cause, method of disposal, corrective action implemented to prevent spills from reoccurring.
So under description of materials, can you read the full description in that column?
Description of materials. An analysis is required if spill is of unknown origin to determine type of treatment or remediation required for proper disposal.
Thank you. And what are the date ranges covered by this log, referring to both page 3 and page 4?
The dates range from December 20th, 2024 to February 18, 2025.
Okay. Under the column description of material, what do most of the entries in this log state?
Water, soap, and nickel.
Okay, and a few of the entries in the description state water or water soap, correct?
That is correct.
According to the log, what is the most frequent entry for cause?
Clean pits.
Reading the first entry line on page 3 of the exhibit, what is the method of disposal?
Pumping station.
No, can you read the method of disposal? Is there more words before pumping station?
I'm sorry, can you repeat that?
Can you please read what's underneath method of disposal?
Acid alkaline pumping station.
Thank you. And what does the last column of the log indicate?
Corrective action implemented to prevent spills from reoccurring.
And take your time to review the entire log, pages 3 and 4 of this exhibit. Does it appear that any corrective action was implemented to prevent spills from recurring?
Not at all.
Thank you.
Sir, on cross?
Thank you. Let me just clarify, the form you're looking at, is that an AQMD form used for the rule 1426?
Can you rephrase the question? Or
You stated very specifically it was for the industrial wastewater discharge permit. Is there any reference to the South Coast Air Quality Management District Rule 1426 anywhere on this form?
no.
Is the term waste defined under 1426?
No.
Is spill defined under 1426?
No.
Okay. So you have no, I just confirming, you didn't take any samples of this material, so you don't know what it is. That in the original photos of 1 and 2, you have no idea what may be there. You're suspecting? I'm not sure. What do you think is there? In the photographs, the first 2 photographs showing something down in the containment bit.
Would we be able to break that question down?
Sure.
Yeah, sorry.
Let's go to Exhibit 10,
Yeah.
Photo 1. Maybe we can pull that up and that'll be helpful. You believe that it contains nickel. Is there any reason to suggest that nickel wasn't released within an hour when you observed it?
Yes, based on my conversation with on-site personnel.
I'm just referring to the last page of that Exhibit 4 and noticing that on the date in question, you were suggesting that you testified that you were there around 12:30.
Yes.
And I noticed that the site was cleaned as of, at least on the exhibit, 11. So it's now, you're stating that the testimony that you received at the facility now suggests that this was outside of that 1 hour period for release.
To my understanding, yes.
Okay. So maybe I need to ask you a little bit about these collection devices. Are collection devices limited to the area of space between the tanks?
They can be, yes.
Where else could they be?
I'm not too sure at this time.
Okay. Yeah, I think that's all.
Members of, cross, before we go to the hearing board, redirect rather.
I'm okay, thank you.
Members of the
Oh, thank
hearing
you.
board? Mr. Pearman?
How would you define a drip tray, sir?
I would define a drip tray as a, is my mic on? Hello? Yes. I would define a drip tray as a control device to have liquids entering the tank, enter back the tank to prevent any leakage in between tanks.
Say that again, you kind of muddled your words.
Oh, I would define a drip tray as a device to prevent leaking of any plating-based solution from leaking in between tanks.
Have you ever seen a drip tray?
I've seen various examples, yes.
And so we showed Exhibit 8 of the district, there was a containment device. Are you calling this a drip tray or no? Exhibit 8.
No, this one. Yes, that would be a type of containment device, a drip tray, yeah.
But is it a drip tray was my question.
Yes.
So this is called a drip tray. Now, see, my vision of this is that, at least on the bottom, it just makes sure nothing goes between them. So there's no tray, just diverts the liquid between the tanks. But you're saying that that's what a tray is to your way of thinking in terms of the rule.
To my training, that can be considered one as well.
All right, no further questions.
Yes, just a couple questions, sir, if you will, just out of curiosity. Who manages wastewater discharge in Los Angeles County? What agency?
I believe that would be the LA County of Sanitation District.
So help me understand, why is this even germane? Or why is this even an exhibit? How is this relevant to the rule that is before us? And I keep going back to, and I'll keep saying it, I'm going back to the disputed conditions that are not stipulated. So why is this document germane to this particular proceeding? Because this is not an AQMD document, correct? This is exhibit number 10. And so exhibit number 10, if you go to page 3 of 4 and 4, are these AQMD documents?
Those documents were provided as housekeeping by facility personnel. But to answer your question, are they AQMD approved formatted record keeping logs? To my knowledge, no.
So, right, so why is any and all of this information, why is this germane to this particular hearing today?
I can address that in closing. I can address that now.
Well,
Or-
I would like to have it addressed now because we're provided an exhibit 10, and the exhibit states spill containment area materials handling log. So then one would make an assumption that there's relevancy with respect to the annotated notes contained on this document, and then there's a correlation between what we're talking about vis-a-vis Exhibit 2 and the various attachments. I'm just trying to understand.
I can address that as well.
If I may first, and then you
Yes,
can.
yes.
It's the spill containment area materials handling log. It says clean pits, right? So it appears to me that this log is addressing the cleaning of the pits, which is, you've seen those photographs. We've been discussing whether or not there's nickel-based solution in those pits. We see in description of material, nickel here in this column as well. And it also shows when they clean these pits. And in the spill provisions that we've been citing, things are required to be cleaned within 1 hour. We see time of when things have been clean pits and the time noted here.
Okay, so let me ask you another question, sir, and this is my last question. When you spoke with the person, what was the person's name you spoke with on the ground there?
The person's name is Jose Pineda.
Did you ask Mr. Pineda, he stated the solution has nickel-based, et cetera. Did you ask him, hey, when was that cleaned? When was that last cleaned? Has it been there 2 hours, 3 hours, 4 hours, et cetera?
Yes, yes, he did. He said that they clean at the end of their shift. However, their on-site consultant, Bart, stated that they don't have to clean it within an hour. And that's why it will not be cleaned.
And do we have any evidentiary trail of documentation that's hearsay, or do we have any evidence or an exhibit to corroborate their statements and any declarations?
We did not, but as the hearing board may know that you are allowed to have hearsay testimony, and it is also testimony against the interest of the party, and therefore that testimony should be omitted.
You're right, Counselor, you're 100% correct. I guess I'm struggling with Ms. Verdugo Peralta said this, Mr. Perriman said that. I have this document here from Dr. Abraham, Mr. Balakapalan said this over here. I'm trying to piece it all together and figure out exactly like what is really going on, because there's a lot of information and you're trying to make a perfect bow, and it's kind of sort of not necessarily jiving. The pistons aren't hitting, right? So there must be something wrong with the octane levels.
Mr. Chair, yeah, I wanted to at least get my chance to say a couple of things. You'll notice that on the log that was for the sanitation district, that it in fact had been clean at 11 o'clock. The inspector claims he's there at 12:30. So the release could very well have happened within an hour. At most, it was an hour and a half. Now, make that as an observation. The next thing I'm going to give you two more observations for the rules. The rules specify a spill has to be cleaned up within 1 hour. If we're not dealing with the 1 hour rule, the cleanup provisions for containment areas, et cetera, is 1 week. In this instance, the facility has gone above and beyond and does this continuously. They clean every day, not only their lines, but also the containment pits, which would be well in excess of the requirements for containment devices, but would not suffice for spills. And the reason being, just so you understand completely, is you would have to have a full-time person walking around all the facility, all the lines, all the time to try to take care of spills if we somehow construe narrowly this idea of what is a containment device. And so I am trying to get you to the end of this and the attachment C and how this could be resolved. But I'm just trying to give you the lay of the land in terms of the district's position about the 1 hour spill, our position being different, and how we are already doing in excess of one and not enough in the other. And if we try to do theirs, we can't do it because we need full-time people to do it.
Okay, so just my last question, sir.
Sure.
And just to the witness, and perhaps you may can lean into if you so inclined, Counselor. So Valley Plating is located over on Sheila Street. So if we're at Valley Plating, Washington would be north, or would Washington be east? Washington's north.
North.
So from Washington, from Sheila Street, I see there's homes down off of Jillison. Okay, so how far are those homes between Sheila Street and the door of Valley Plating to the residential area?
800 to 900 feet roughly. And I should point out, and I didn't do this indirectly, but the 1426 has no discussion of sensitive receptors in it. Nickel is definitely not looked at the same way as hexavalent and chromium. We certainly understand that.
Well, and I guess where I'm going is, do we have any evidence to corroborate that any of this left the building, right? Is there any way to corroborate? Again, we're trying to understand the risk to the public, right? Do we have any information? Was there any hearsay provided to you, sir, that any of this left the building? Track out, what are we calling it? I'm thinking about something to drag out. So do we have any evidence to corroborate that this has left the building and it's entered the neighborhood?
I just want to state, we have not alleged that it has left the building.
So then let me ask you a question. So then Exhibit 4, why do we provide Exhibit 4? Why do we provide an exhibit to the hearing board simply underscoring that there may be a I'm looking at this as a potential threat to public health and safety, or public health rather, and safety as well. And so if I receive this document as a member of this hearing board today, never received it any time before, got it today, I'm drawing a nexus between the fact that potentially Ali is going to walk out of here and track something or another across the street. So what was the purpose of providing this exhibit?
The purpose is to provide background as to where it's located, and as you know, the purpose of Rule 1426, and let me refer to the rule. Is to reduce fugitive emissions of hexavalent chromium, nickel, cadmium, lead at metal finishing facilities. So all the different provisions in the rule serves to reduce fugitive emissions and not one thing in particular. And we have not provided evidence that it actually left the building, but every single best management practice, every single housekeeping requirement serves this purpose and serves to protect the community from potential fugitive emissions.
Okay, so my questions are in fact in alignment with what you've stated, because how do we define, what is a fugitive emission?
Under 1426, it means any hexavalent chromium, nickel, cadmium, or lead particulate matter that becomes airborne by natural or man-made activities, excluding particulate matter emitted from an exhaust stack.
So the implication or the prevailing belief of anybody receiving this exhibit in hand would draw a conclusion that there's a potentiality that a fugitive emission with an S could in fact leave the building. And I want to confirm that it did not leave the building, irrespective of verbal testimony, right? I'm drawing a conclusion because I want to make certain that we're protecting the community, A, but B, I don't know when in fact, I have no idea if there was a spill and one of these individuals cleaned it up and didn't log it, how would we know? Because this is not even an AQMD log. This is the LA County SANS log. So again, put yourself in my position. I'm listening to a tremendous amount of testimony this morning, or this afternoon rather, and trying to draw correlations and trying to also make assertions and kind of fill in the blanks. So again, I won't have any further questions. I'm quite sure other folks may have some questions about like a Kapalana.
Thank you, Mr. Chair. Mr. Vergara, can I bring your attention to Exhibit 2 attachment, previously listed as Attachment C? And the first finding.
Apologies, let's look for this document.
You have that, yeah.
Yes.
Can you read the first finding?
The first finding states, the area beneath the tanks, also known as the pits, is not a drip tray or other collection or containment device.
Okay, so, and then when we look at the log for that the facility is doing for the LA Sanitation District,
Correct.
what does it say in the heading that it's the main heading, but hold on. Looking at the log, where it says spill, what does it say after that?
Spill containment area materials handling log.
So they're considering that as a spill containment area. Is that your understanding?
Correct, that is my understanding.
So it says the finding says area under the tank is not a containment area. They're saying that, I mean, and this is presumably LA Sand District has agreed to it. You know, that's the log they're keeping for them. But do you see the problem they have? One says it says it's a contained area. Let me ask you another follow-up question. Let's say for whatever reason, the tank above spills, breaks or whatever, and the liquid, where does it go? How does it get contained when they spill?
If a tank were to spill, it would be captured in that concrete pit, yes.
In that, and it'll be contained in that area. Is that the reason why you see the berms there at a certain height? So that it can capture the liquid?
Yes, it
Most
does.
of it at least.
I guess that's a fair assessment.
Okay,
That
all
it
right,
can.
All right, so it'll be contained there, potentially. Okay, no, that's fine. Okay, thank you. I have no further questions.
Ms. Verdugo Peralta.
This is much more of a, I guess, observation. I'm very familiar with the city of Commerce. My husband grew up there. And this is not just where they had that white line of sensitive receptors. It's obviously less than the 1,300 linear feet from the facility to the neighborhood. And that whole entire neighborhood is a Hispanic community. And they are mostly either low, medium, or low income for the most part in that area. But this is also a cumulative issue. It's an environmental justice issue. Which, if you panned out, if you zoomed out on this photo, the railroad tracks are not very far away from this at all. And not to mention the freeway, I think the 60 freeway and the 710 freeway
710, you're right.
are all there. So it's a cumulative issue that I'm looking at, and I'm looking at this, I mean, besides who's calling what, and a definition of this and a definition of that, the whole thing that I am perceiving here is if there are emissions or not, and is it contributing to the cumulative effect and the health risks that these residents are experiencing. And that's, we're just going back and forth here. We're just going back and forth of who's calling what. So I really don't care what you call it. Is it affecting the public or not? That's what I want to know. So can you answer that question? Is there a health risk that has been assessed at all? Yes, yes. I'm asking the scientist. I'm asking the man who has been in a lab and has processed many, I would suspect, examples, if you will. So that's what I want to hear scientifically.
Ms. Verdugo Peralta, Ms. Lewis does have information on that point. So if you would like me, if it is all right, I could recall her.
I'm going to object for that because that is talking about direct air emissions from the facility, not fugitive emissions. And I know that.
Fugitive emissions, air,
the important point we are talking about is fugitive emissions.
Then fugitive emissions.
Yeah,
Yes, I'm fine
then
with
if she has specific information to risk on fugitive emissions, please, she can present.
I also want to hear from a scientist. I want to hear from a man who has been in a lab, who has been conducting these types of tests, and I want to hear what his take on this is.
So we're going to sustain the objection, and to Ms. Verdugo Peralta's query, can you speak to, you're the scientist, I do believe, and so can you speak to her point?
I can't speak fully to the point as I'm not aware of any current studies that the facility has conducted on any fugitive emission sources at this time that may affect the public, which include potential fugitive dust.
Are you saying Ms. Lewis can?
I haven't had a chance to discuss with her the information that she has fully, so I can bring her up and you can ask questions of her regarding the information that she has regarding an event in 2020.
I'm just trying to get to the point.
Now, I just want to, let me just be very clear. As you were talking, Dr. Lewis was shaking her head no. So I want to be very clear so we don't prolong this. Either she knows or she does not know. And if Ms. Verdugo's question can't be answered today, I'm perfectly fine with that. At some point in time, we will get it answered. But I don't want to bring Dr. Lewis back up if she doesn't have anything to add substantive.
I mean, Do you want to take a break, or would you rather just direct questions at Dr. Lewis
We can
directly?
we can bring her up and we
Okay.
can direct
Thank
questions,
you.
yes.
Again, I want to make sure my objection is noted that this is for fugitive emissions only.
Yes, no, and I clarify.
No, that's very important.
I qualified that I
Thank you.
sustained the objection, but when we want to hear from Dr. Lewis with respect to fugitive emissions only.
Ms. Lewis, you had mentioned that there was a complaint in 2020. Can you please describe the complaint?
Yes, South Coast AQMD received a complaint regarding chrome, lead, zinc, nickel found on the roof of the facility. So that is outside of the facility, and
And for the facility, you mean valley plating?
that is correct.
Okay, and what was the result of this complaint?
It was a complaint where sampling was taken, and it was indicated that there was elevated levels of total chrome, lead, zinc, and nickel. And from this report, it states that the facility results have demonstrated levels were above action levels.
And
then
where
it just
did the report indicate where these samples were taken?
on the roof of the facility.
Thank you, and I will turn it over to Mr. Pomeroy if he has cross or.
Is there any information based on what you've just stated that these are in fact samples of fugitive emissions?
They are samples that were taken outside of the facility on the roof of the facility.
Where does the roof, where do the emissions from the tank lines go outside of the building? Where is the first place that they exit the building from operations? Direct emission operations. Where's the first location that you would find these emissions? Would it be the roof?
So there are a number of ways that emissions can be released from a tank.
I understand you took samples on the roof and the district samples there for emissions either as a source or a stack. Is there a description of this, whether this is a source sampling or a stack sampling?
I did not take samples at this facility.
No,
nor
but you
did
have the report. I'm just trying to find out what it says.
Nor did the district take samples. These were samples were taken by another party.
Okay, so none of the samples were actually taken outside of the perimeter of the property.
Right, but
So there's no proof based on this data that there has been an emission that actually,
She did not
is-
finish her answer.
oh, sorry, please go, keep going.
where's the rule?
Was that the rule?
No.
Oh, sorry.
1426.
You know, honestly, I would really prefer to strike that testimony from the record. Because it's not germane, it's not relevant. It's 5 years ago, there's nothing to substantiate. Ms. Verdugo-Peralta asked us, we're talking about the 900 feet, not the parameter of the building. Right, we're talking about the general community. So I'm struggling with this. Ms. Verdugo-Peralta, the floor is yours. You maintain the microphone.
Well, obviously, we all know that emissions don't stay within a block. They go everywhere. And there's no way that any company can contain if there are emissions that are escaping. And the emissions, you know, the material may be on the roof from a spill, from overflow, whatever it is, it still has the ability to create the emission and go throughout that whole entire area. We don't know how far that it's gone, but obviously it has that potential. And if it's within even the 1,300 feet of a sensitive receptor, whether that is called out or not, it's occurring. It's there. And we know that it's there. And there's no way that I can see that they are capturing it. So, you know, when you're saying emissions, emissions can come from something that is solid and it still can create an emission. So I cannot go with the argument that, well, if it's on the roof or did it come from the tank or whatever, it's there. It's there. The inspectors know that it's there. They're telling us that it's there. And it's the possibility for those fugitive emissions to go beyond the square footage of the building, let alone the property, is very possible.
All right, any additional witnesses?
There are no more district witnesses.
Thank you very kindly. Mr. Pomeroy, the floor is yours, sir.
Chair, could we take a 5-minute break?
You know what? Why don't we go ahead and take a 5-minute break, Mr. Pomeroy? We'll come back. We're going to go off the record and come back in 5 minutes. We're back on the record?
Yeah.
Back on the record at 2:19 PM. And the floor, Mr. Pomeroy controlled the floor at this moment.
Thank you, Mr. Chair. Can I have your name as the witness?
Matthew Cullen.
What is your title at Valley Plating?
I am an owner and vice president of operations. Cullen, Cullen.
How long have you worked for Valley Plating?
All my life, actively as an adult for, I don't know, 30 plus years.
So in your role at the facility, what type of things do you do specifically?
Well, all sorts of things, soup to nuts. I'm an owner. Well, I don't understand.
All right. Do you deal with compliance issues?
Of course.
And do you deal with the basic operations? of
Yes, I do.
The lines. Okay. Does the facility presently have any hexavalent chromium on its lines?
No, it doesn't.
And was the hexavalent chromium decorative tank discontinued?
May of 2023.
So as far as the metals that are described under Rule 1426, what metal do you have that is regulated under that rule?
Nickel.
Did you help in the building of the tank lines?
Yes, I did. I personally spent 3 years building it from the ground up.
Can you give me a little bit of a description of what you did in putting this system together, the systems together?
Sure. So, first, we dug the pits, as the foundation. So we dug the holes, graded it, compacted it, installed a geotech subliner, which is seam sealed. On top of that goes the concrete. On top of that goes the epoxy paint. And then from there, we start installing the equipment for the plating line and the strip line.
How did the equipment get put onto that containment area?
Well, I think there's some photos that kind of show it. There's piers made out of concrete that elevate the tanks off of the surface of the pit, and then of course level them all too. And then you install the tanks and bolt them down with seismic restraints and so forth. Of course, actually, back up. First, we build the gantry, which contains the mechanics of the machine and the conveyor and the side arms that you hang the parts on. Then you put the tanks in, and then you finish it up and make up all the solutions, start plating.
Let's refer to Exhibit D as in dog. It's a photograph. And I know I don't have it up on screen. Sorry, I don't have that technology, but you should have it in front of you. Can you describe a little bit of what the hearing board members are looking at here with Exhibit D?
Okay. This is, I'm trying to figure out which direction we're looking at. Well, okay, so what you're seeing is the catwalk grading, obviously. That's where the operators work. And
I'm sorry, excuse me. Can you just share that real quick? What you're looking at?
We're looking at Exhibit D. D as in dog.
D as in dog? Okay.
yeah, it's an overhead shot of the production line on one side. So you can see the different tanks, the things protruding, sticking out over the tanks are what carry the parts and the current to allow the process to work. And then the machine goes up and down with an elevator and around with a conveyor. And that's how that works.
What is the area between the tanks?
So, okay, so yeah, I've heard this talked about more so today than maybe in my entire career. So you'll notice on the lips of the tank, we wrap from one tank, maybe 6 or 8 inches below the surface of the tank, the level of the tank, with fiberglass, go up over the top of that tank, bridge to the tank next to it, and same thing, back down into the subsequent tank. And that is, to prevent any liquids from going in between, getting in between the tanks and running down the sides of the tanks and so forth.
So is that a collection device or a drip tray, or how does it somehow meet the terminology that is getting thrown around in the rule today?
Yeah, I have a hard time calling that a drip tray. It's not logical to me, but and it's neither is it a collection device. It's honestly, it's just kind of a diffuser cap, if you will, but it meets the definition of keeping the drips from going in between the walls of one tank to the other.
Okay.
That's its purpose.
So there are a couple of areas where this is not this situation, but can you explain how frequent you have this system in place? Is that generally these 4 tanks, or is it more? Or is
No,
it less?
it's
What is
every
it?
tank on every line, for a lot of reasons. I mean, the most practical one is you don't want, even if it's the cleanest water in the world, you don't want it going down the side of a tank and rusting your tanks out. You gotta keep them clean and dry. Not to mention, all the other good reasons, which is to minimize any cleanup that we may have to do after we run a shift of production.
Okay. So let's move on to something that is the other issue, which hasn't been discussed or described today in, too much, but we definitely want to get to it. Can we look at, we'll start with Exhibit E, and maybe you can describe for everyone, Exhibit E is an elephant, what we are looking at.
Okay. Well, that is our machine operator. He's got his fall restraint system on. If you guys, I don't know if you all have a copy of this
Yeah,
one.
they
That's
should have.
what I'm referring to.
We should have a.
Okay. So that's Miguel. He's actually at the end of the line on a drip tray. And you've seen a picture of this drip tray at least once today. From district council.
We'll show them that as well.
So
but-
anyways,
but-
that's what you're looking at. He's out, the catwalk would be on the other side of the handrail, if you can make that out in this photograph. So normally you wouldn't work here, but there are times when we have to go out into this area of the line for various reasons.
Well, can you describe some of the reasons why you would need to access this area?
Sure, you can see what he's doing there is he's adjusting a part. So as the parts are on the racks and they're on the arms and they move through the process, things can happen. They can get jostled loose. They can slip off the rack tip. Well, you got to fix it. So you got to stop the machine and fix it. Otherwise, the next arm's going to cycle. It's going to cause more problems. It's going to be a pile up. It'll be like look like the freeway. It'll rip your machine apart. I mean, you have to stop and you have to clear the problem. You have to fix it. That's one of the reasons. But I couldn't list them all. There's probably 1,000.
Well, how often does someone generally go out on the line? I mean, do you have a ballpark? Is it once a day?
Maybe.
Could be once a day.
Maybe, unless we're testing a new part or something that's somehow problematic, and then it could be more frequent until we solve the problem.
So we're stepping out on what you've described as a containment device. Do you do anything in advance of, in terms of cleaning that before you go out onto it? What do
Yeah.
you do?
Yeah, so the operator from the catwalk will get the hose, rinse everything all down, and then he'll open up the gate on the safety rail, hook up his harness to the overhead fall restraint system, and then go out into the production line.
Okay, you made a reference to another exhibit that had a better, or a, we'll call it a more colorful photo of
Yeah.
it. I'm going to mention it's the district's number 6, exhibit number 6.
That's
And
it.
so can you tell me a little more about this containment device?
I assume you're talking about the one.
Yes, the one I'm stating is the one, it's the large brown one on the
Mhm.
front at the bottom of that photograph.
That would be
basically.
it, yeah, so that's what we've always called a drip tray. And it's fiberglass encased, and it slopes to either the tank that you see here kind of center in the photograph, which would be the previous tank, and then it goes around the corner. You see, can't put a tank there, so it's kind of a dead space. Well, we don't want the parts dripping into the containment pit constantly, so we put the drip tray to then, whatever drips from the parts goes either to the rinse tank previous or the rinse tank following.
Great. Let me,
I just ask, I don't understand that at all.
Okay, can we?
Exhibit number-
How about we reference the overhead?
yeah, it's the overhead.
Is that in there?
It's exhibit number
With the-
6.
With the district, could you put that up since you had it in yours before, or is that not something you had available?
Yeah, the kind of the plot plan, the top-down view,
This is what,
the map of the tanks, then I could
Oh, yeah,
explain, I could explain exactly what we're looking at.
Right, so why don't you hold on one second?
Yes.
Let's get the districts. There we go. Is this,
it's exhibit number 6.
all right, exhibit number 6.
Well, this is, okay.
okay, so show me again the drip tray, et cetera, in there. You.
Yes.
Well, no, I understand this is exhibit 6. I'm
Yeah, but
confused.
Just identify for him what
Oh,
is the drip tray.
what am I
Yeah,
calling
no,
the drip tray?
Describe it if you
That.
can, the brown at the
Yeah,
bottom
the
of the
brown
photo.
thing that would be on the floor, let's say, the perspective of this photograph. Does that make sense?
No, okay, so hold on, so
Yeah.
is this the floor? Are we looking at the floor or? are the
Well,
floors-
that's the top of the
Okay, so the yellow
tank,
part, the
yeah.
yellow part is where the floor is.
No.
Okay, so can you kind of walk us through this? Give us
Okay.
the Cliff Notes version of what this is.
Okay, so what we're looking at, can you see the two tanks kind of in the center of the photograph there?
Yes.
Okay, so that's the top of a couple of rinse tanks at the very end of the line. So what I'm trying to describe, and I guess I'm not doing a very good job, is the fiberglass that goes, let's say, from the lip of that last rinse tank. It actually connects and goes down into that tank. It's fiberglassed into it, kind of like we fiberglass from one tank to the next. Okay, and so that prevents anything from, as the parts are coming around the corner, making the turn 180 to go the other way. This contains anything that's dripping from the parts, and it slopes back so, it can drain back into the rinse tanks.
So is the lighter brown at the bottom half, is that the fiberglass?
Yeah.
Okay.
Any other questions of this exhibit? And Mr. Palmer, the floor is yours, sir.
Thank you. All right, so we're trying to do a little bit of a description on the tank containment, and we were also talking about the system that you've devised for purposes of the safety, and we've shown you Exhibit E. What about, and just show me Exhibit, I'm going to look at Exhibit F, and maybe you can describe what he's doing in this situation.
All right, that's Miguel again. In this case, he's in the center of the machine. The catwalk where, normally the operator stand would be to the far left, not really, you can't really see it in this photo. So he's at the back of the tank. He's on a rinse tank and he is fishing a dropped part out of the rinse tank with a big hook.
So for both the descriptions you provided for exhibits E and F, in terms of walking on the containment devices and drip trays, please reconfirm what's the step and process for him doing this?
Sure, yeah. So again, he would, notice, hey, we got a dropped part. Stop the machine, grab the hose on the catwalk, rinse down the area that he needs to access, and then he would go out over the line there and do the work.
Okay. So that's perfect. Thank you. All right. So what I guess the last thing I really want to go into for purpose of this is we have an exhibit G, which is a very dark photograph. Apologies for that, but it's dark down there. So can you tell me a little bit about what exhibit G is showing?
Sure. So this is our containment pit. So let's say to the far right-hand side of the photo, the vertical concrete structures are the piers. That's where the tanks sit and we bolt them down to. In between, it's just, I guess, interstitial space. And its purpose is, this pit's, I don't know, 4.5, 5 feet deep at its deepest point. The floors are sloped from one side to the other. In the middle is kind of what you're seeing in the bottom third center there. That's a sump where we would put the hose as we clean out the pit to get all the liquid out with a pump, and then you finish up with a mop. And that thing on the left-hand side is filter pipe.
What is the pipe attached to?
It's attached to the wall, the vertical wall of the containment pit. You'll see if this photo were not so zoomed in, I guess, you would see the floor level would be, kind of at the top of the photo.
So about how deep is the pit?
At this section, the very, where that sump is, it's probably about 5 feet below the floor level.
So if there was any form of a drip, a liquid that didn't somehow stay in the tank above, where would it go based on your system?
Into this pit, or one of the pits that the entire line is, the pit's much larger than the actual plating line or the strip line, if you want to talk about that.
Could drips or any of the liquid that we're describing end up in a walkway?
In a walkway?
Yeah.
I suppose in some bizarre universe, perhaps, but this is not a walkway.
So how far does the pit extend away from the tanks? How many feet do you think?
Yeah, a rough estimate is about 4 to 6 feet, right in there.
So is it your view that Rule 1426 and the term containment device is applicable to what you have as containment under the tanks as well?
Yeah, I refer to all these systems as containment in one way or another. I don't typically call them a device, but sure, we'll call it a device.
All right. So I want to clean up a couple things just to make sure everyone's clear of what we've got. So can we turn to the district's exhibit number 9? And the district's exhibit number 9 is 3 photographs, and I'm looking at, and these are photographs that relate to a certain area that was photographed by the district, and I'm referring to the second one. And can you identify the date that's identified at the top of that photograph?
Says June 7th, 2024.
Are you familiar with activities in and around that area as of that date?
Yeah, I am. What we're looking at is the tank on the left would be tank 27. Tank on the right would be tank 28. So the semi-bright nickel is on the left, bright nickel's on the right. The pipe that you see connected to the tank on the left is a supply line going to our nickel filter, coming off the bottom of the process tank. We have 3 of them. They come off the tank at the bottom. They go underneath the plating line where the filters are on the other side of the line. And so just prior to this date, we had done a yearly maintenance project whereby we pump out our nickel tanks. We remove the anode baskets, replace the anode bags, clean the tanks thoroughly. Part of that cleaning process is we remove the filter pipe. You can see where that valve is. You've got 2 flanges there. Well, we piped it like that so when we have to do the maintenance, we can disconnect this pipe from the tank to make sure we get all the stuff out of the tank. And then we put it back together when we're done with the project. So what you're looking at here seems to be some residual stuff from this activity that was still going on. We started days before this inspection, and we concluded it, I want to say the following day, Saturday.
So the liquid or the supposed nickel that's identified, the green coloring, did that come from the top of the operational line?
No, it came out of that pipe.
Okay. But is that area in containment where the pipe
Yes.
is located?
Yes.
Did it get into the environment?
No.
Were there any workers exposed to this?
No.
Do workers walk on that material?
No. You clean the whatever containment device you may be trying to access. Of course, you wouldn't. I mean, you don't just step in anything. You wouldn't step in a pile of grease. You wouldn't step in any chemical. You clean the area first.
So when you do cleaning in the pit area, can you give me a little description of the process of how you go in and clean it?
Sure. So we get I hope I don't get in the weeds too much. You get like a 2-inch diaphragm pump. And you put the suction side of the pump down in that sump that we had a picture of earlier. And then you start hosing down the area, the section of the containment pit that you want to clean. And you pump it up and until the rinsate is looking, hey, look, we got it all. And then you shut the pump off. And then at that point, it's perfectly fine to go down in the containment pit and finish up the small section, you know, with a mop and a bucket. And then you take that and put it through waste treatment.
So can you tell me whether this complies with Rule 1426 and you can read approved cleaning method and tell me if it meets those requirements?
Okay, Rule 1426, paragraph C4. Approved cleaning method means cleaning using a wet mop, damp cloth, wet wash, low pressure spray nozzle, HEPA vacuum, or other method as approved by the executive officer.
So does your method that you've just described meet that requirement?
Yes.
Is any worker exposed as a result of the process you've just described?
No.
Is there any foot traffic or walkways in the containment pit itself?
No.
What are the only times that people would actually go into the containment pit itself?
Either for wet maintenance activities or perhaps mechanical maintenance to the motors and things in the middle of the machine.
And cleaning also, right?
Well, of course, yeah. You clean it before you go there, yeah.
Right. All right, well, I think that does it for me in terms of the basic information, so you have an understanding of what it is, and so I'll leave it to district to provide cross-exam.
Ms. Sue and Cross?
Mr. Collin, let me refer you to Exhibit 6 of the district exhibits.
You'll find it, we will.
Yeah, I don't have a copy of everything at the moment.
I'll try.
Okay.
We'll find it. We'll find it.
Is it not the end?
No.
Okay.
There it is. We got it.
There's a label that says September 24th, 2024 on it. Mr. Collin, do you see Exhibit 6?
Yes.
And is what's in the foreground, kind of the brown area, what you're describing as a drip tray?
Yes.
And you state that the personnel will rinse this so-called drip tray before stepping or walking on it?
Yes.
And you said they may step on it maybe once a day?
It could be once a day. It's probably a few more times than that, I would guess. Yeah.
Okay. Is there a requirement in the rule to rinse a drip tray prior to stepping on it?
Yeah, sure. Well, a drip tray per se, I don't know.
Where in the rule does it say that there's a requirement to rinse off a drip tray prior to stepping on it?
See?
It doesn't.
Okay. Thank you.
Oh, I know what this one is.
I've passed out another exhibit. Ms. McCune, what number are we on?
11.
11? To mark this as Exhibit 11, admitted into evidence.
Yes, it is marked as Exhibit 11 and accepted into evidence.
Mr. Cullen, do you see a tank in this photograph?
Yes,
And what is the tank number of this photograph?
it does
Yeah.
not have a number on it.
Do you know which tank this is?
I could guess.
Okay, what
Do
is?
you know what tank it is? I mean, this is not my photograph.
I understand that.
Okay.
Do you recognize this tank?
Maybe. Yeah,
Do you believe this is a tank at your facility?
yes, I do.
Okay. And do you see that there are streaks running down this tank?
Yeah, I see that.
Okay. And do you see that there is a liquid pooling on the bottom of that photograph?
Yes, I do.
Okay. And you can't say what tank number
I
this?
believe that's tank 41, which is no longer in the process. It was the hexavalent chromium plating tank that we ceased operation on in 2023.
Okay,
So this is an old photo, right?
correct.
Yeah.
And what is to the right of this tank, the thing that is striated to the left?
Is what she's trying to.
Oh,
Sorry, the green.
that's a rectifier choke.
Okay, does that provide
Tell you more.
I would like to learn more, but maybe outside of the hearing. Does that provide you information as to which tank this is?
I believe so. I believe that's tank 41.
Okay, great. Thank you. Thank you. I have no further questions at this time.
On redirect? Mr. Palmer, on
No.
redirect, okay, very well, Mr.
No redirect.
All right, hearing board members. Mr. Pearman,
So I want to be clear on what was Exhibit 9, the second page.
Oh.
And
Yeah.
okay, and your Exhibit G, or what was first 7, is what you call the containment pit. Okay, so I'm trying to understand
Okay.
this area on 9, second page, that kind of green striped area at the bottom. Is that on the floor of the containment pit? Is that above the containment pit? Where would you describe that as?
I'm sorry, I lost you a little bit there. Which exhibit?
So 9, second page,
Which is this?
the kind of green area on the bottom that
Uh-huh.
at least the district said might be metal or dried metal.
Yeah.
Is this area on the floor of the containment pit, or is it
Yes.
above it, or where?
Yeah, that's at the bottom of the containment pit.
Okay, okay, thank you. Now, I want to ask you something in terms of possible conditions. Let's assume for the moment that we did not agree with the district's finding 1, or didn't deal with at all as to whether your pit is a drip tray or other collection or containment device. I think your attorney stated that in any event, you daily clean the collection pit area. Is that true?
Yeah. Mhm.
Okay, so would you agree to cement that daily cleaning in a condition if we requested it, that you would clean it daily?
You know, the problem I have with accepting these conditions is it seems like we're making new rules. And that, I don't think this is the proper way to do that.
Well, we have a broad discretion in terms of conditions, but you could certainly have us rule.
Okay, all right. Yeah, since we're,
That's the difference. Daily versus weekly. That's versus hourly.
I object to the council counseling the metal questioning.
I was
No,
trying to
I'm
understand.
asking about the condition that we might grant,
Yeah.
so I want them to agree to it. if that's
Well, we
okay.
do it. It's okay. If you want us to log it and stuff, fine. But hourly,
No, stop. My question was, would you agree to put in a condition that you, as you promised already, you do it daily?
yes.
Okay. So you'd agree that the containment pit or collection areas you described then would be cleaned daily. What about the drip tray? The same thing? You could do that too?
Sure.
Okay, good. Now, if we show the witness attachment C, the disputed conditions, Mr. Pomeroy, so we can focus on that. One condition the district wanted was that you should not walk or step on drip trays or other collection or containment device. It seems to me your attachment is, except when you're cleaning, you don't do that. You don't walk on those areas, correct?
Well, we walk on them occasionally, but
For what purpose?
sometimes to go out to attend to a dropped part or, you know, to fix something on the machine. But it's always cleaned prior to accessing, you know, to walking on it.
So would you agree that you have or would agree to a best practice of cleaning those areas before, for maintenance purposes or cleaning, otherwise you wouldn't walk on them?
Yeah.
And then the district had talked about a proposed condition if there was an accumulation of liquid was observed beneath the tanks, cleaning it within 1 hour. So right now, if there's liquid beneath the tanks, when do you get to it?
It's daily. It's typically at the end of the shift.
And what's the problem with doing it more frequently than that? Like 4 hours after you notice liquid?
Well, if we have somebody available to do it at that moment, that may be fine. But if we clean it at the end of every shift, it seems to me like that would take care of it.
And how many shifts a day do you have?
One.
Okay. So your practice is if there's liquid observed beneath the tanks, you clean it before close of business that day?
Yeah.
Okay. All right, thank you very much.
Mr. Balakaplong.
Yes, Mr. Cullen, back up a little bit. What parts do you plate, like nickel chrome plating, right? What are the parts that we're seeing there? What are those?
No, I don't know which.
They're in-
But I could tell you in general, we built that line to do shopping carts.
Okay.
Not a lot of those in chrome anymore. But what we do currently is a lot of industrial furniture for like schools, school desk chairs, all to motorcycle accessories to, oh boy, you name it. If it's
So what are we seeing in the picture? Handlebars?
I don't know, but maybe. See, what do we got here? That's let's see. Exhibit 6, that'd be Verco Manufacturing. That's chair frames.
Yeah, okay.
Mm-hmm.
I did notice a condition not to buff polish. You don't do that?
We used to.
So where do you do it? Outsource it or
We outsource it, yeah.
you don't do it at your facility?
We don't do it ourselves anymore, no.
Okay. But somebody else is doing it for you. Customer
Well,
might require.
I usually, since we don't manufacture the parts, we just ask our customers to get it polished and then bring it to us.
I see. Okay.
Yeah.
And I don't know if your attorney is going to get into this or not, but there is a exhibit 3 of your exhibit. There's a regulation that, and I don't know if that's what he was pointing to you.
The next witness.
Oh, the next witness. Okay, that requires cleaning within 24 hours. So I think that's what the sort of Mr. Pearman's condition altered.
Got it, yeah.
Okay, got it. All right. Okay. Thank you. I got no further questions.
All right, any additional questions of this gentleman? Okay, thank you. Next witness?
Next witness.
5-minute break. I need to rest.
Okay, well, we're gonna go off the record, back on the record in 5 minutes. being very efficient with the government fist. All right.
There you go.
This, you know, for it to be the late afternoon, you guys are a while loud, okay? We're back on the record. Back on the record at 3:02 PM. Mr. Pomeroy, the floor is yours, sir.
Thank you, Chair, Mr. Chair. My next witness, could you provide your name and spell the last name, please?
My name is Bart Hamlet, BartHamlett.
What is your title?
I'm the president of BNC Engineering and Wastewater.
Can you tell me a little bit of what that entails, that business?
I'm a consultant that helps and assists metal finishers and other industries with regulatory compliance.
Okay, well, if that's what you do, how long have you been doing it?
I've been doing it for approximately around 30 years.
Does that, can you describe a little bit of what that is exactly that you do?
Yes, but let me go ahead and break it down. I was previously working at EEC as a consultant. Then I started my own company back in 2009, and I've been running my own consulting firm, assisting industries with compliance with the fire department, with South Coast Air Quality Management, with the sewering agencies, whether it be LA County Sanitation District, Orange County Sanitation District. We also assist with industrial hygiene, audits of facilities, making sure that they're meeting all the regulatory compliance with all those particular agencies.
Do you also get involved with air emissions issues and compliance?
Yes, we also help calculate the air emissions for metal finishers. It was, I think, annually, and then we also help draft and submit permits to South Coast Air Quality Management District.
Are you familiar with rules 1426 and 1469?
Yes.
For the purposes of this evaluation, is there something we should know between a difference between the two of those regulations?
Well, the 1469 is really predominantly taking care of your hexavalent chrome emissions, and then 1426 deals with also hexavalent chrome, nickel, and lead and cadmium emissions.
Okay. So in reviewing 1426, have you seen the term containment device identified in Rule 1426? That's in the Exhibit A.
No, I haven't seen any definition within the definition section.
Okay. What about for spill?
No.
Okay. Is there a term or definition for waste?
No, there is not.
Okay. So based on, and certainly you've identified your qualifications for environmental issues. And so you've looked at what 1426 requires for certain aspects of containment devices. What kind of containment devices does Valley Plating have at its facility?
Well, they have the containment devices where the tanks are, at the lips of the tanks. They also have the containment device, which we're calling the pit, which is really a secondary containment device around the tanks for both process lines.
All right. Well, that kind of gets us to that. Let's look at, and I want to draw your attention to Exhibit C. And Exhibit C, can you tell me the title of that?
Yeah, this is Title 40, Protection of the Environment.
And for what? Protection of the environment for what? In what context?
Well, this is actually the secondary containment system that's required for any industry that has any type of hazardous materials to be able to protect the environment from any spills.
Right. Are there different kinds of containment devices that they describe in there?
Yes, there are.
Can you tell the board a few of the things that they're?
Well, there's containment devices that have detection systems on them. There are containment devices that slope over to a sump that will pump that spill over to maybe a holding tank.
Are the operations at Valley Plating, do they comply with your understanding of containment device now that you've looked at that particular section?
Yes.
What, does that section specify a time limit in terms of the cleanup of it itself?
No, I don't think there's anything, I think it's 24, what? Okay, yeah, it does, sorry. It stipulates here that it's within 24 hours.
Okay, there's no requirement to address any form of spill in the containment within an hour.
No,
Is this the AQMD's rule that you're reading from?
no, this is not.
Okay. Does the AQMD have, and I think you've already said this, you don't have a definition of that term, so how are you using this information in the context of no definition being present in the rule?
Well, I would assume that they would be adhering to this rule, that they would be telling us that our secondary containment needs to be able to contain a spill, that you have 24 hours to be able to clean up that spill. That's exactly what we thought they were referring to because there was no definition in the rule.
All right. That's it from me.
All right, my friend, Miss Sue Cross.
Good afternoon, Mr. Hamlet.
Good afternoon.
Referring you to Exhibit C, Section 267.195, subsection A1. Can you read A1 for me aloud?
Yeah, A1 says secondary containment system must be designed, installed, operated to prevent any mitigation of waste or accumulation of liquid out of the system to the soil, groundwater, or surface water at any time during the use of the tank system.
Thank you. Do you see the word air in there at A1?
No,
Okay. And you have responded that there's a 24-hour cleanup provision in this regulation, correct?
correct.
And referring to the district's exhibit, Exhibit 10, I'm referring to the spill containment area materials handling log.
Log.
Is this log supposed to show compliance with this provision? B4?
Well, this log is for LA County Sanitation District's provisions. It is showing that they are pumping out waste that looks like once a day.
Okay. Does it show when the facility cleans the pits?
Yeah, it has a date and a time.
Okay. Thank you. I have no further questions at this time.
Members of the hearing board. All right, sounds like there's no other questions. Let's move to closing. We'll go ahead and go with the Ms. Sue. Petitioner, closing.
Good afternoon. As you heard testimony, nickel is a toxic air contaminant. There's no requirement for the district to show that there were fugitive emissions in order to enforce the rule. The facility would like you to believe that so-called drip trays that they walk on once a day, potentially multiple times a day, and this is on the tank line, that is a drip tray. They do have testimony that they do wash that area prior to stepping on the so-called drip tray. I would like to remind the district that There is no provision in the rule that requires them to wash down prior to stepping on a drip tray. So after the term of the abatement order, there will be no requirement to wash down the area that they are stepping on prior to stepping on it. Looking at the frequency that they're stepping on the so-called drip tray on the line, it leads us to believe that it may be used as a walkway and not a drip tray. Additionally, the facility would like you to believe that the area, the pits underneath the tank, is a secondary containment device. They showed you the federal regulation regarding secondary containment device, and that secondary containment device does serve an important purpose. It prevents the migration of waste or accumulated liquid from reaching the soil, groundwater, or surface water. We at the AQMD are concerned with air emissions. Our provisions in Rule 1426 are concerned with air emissions. The purpose of Rule 1426 is to reduce the likelihood of nickel and other metals from reaching the community. Every single provision, every single housekeeping and best management practice is important. As we chip away at this, it would lessen the protections that we have for the community. This is why we would like a finding that the area beneath the tanks, also known as the pits, is not a drip tray or other collection or containment device. I would like to remind you that you saw photographs of hoses being stored in the containment device where there was liquid pooling under the hoses. What would happen when someone moves the hose? They also say that they clean at the end of the shift. You saw photographs at around 12:30 shown with the witness, Mr. Vergara. That happened at 12:30. You see on the cleaning log, they clean about 10:30 to 11 a.m. every day. But there was a spill there, or there was liquid there, and it would be there overnight. We also are seeking a finding that Valley Planning violated Rule 1426 E3A by not cleaning spills that may contain nickel within 1 hour after being spilled. You heard testimony from Mr. Cullen about the photograph with that pipe that Ms. Lewis had presented, that dried accumulated solid material. And he was explaining they were maintaining a tank and that it was a multiple day process. It is still a spill, even if they did not come from a tank, even if it came from a pipe. He said it came from the tank, they were taking things out. That is likely nickel containing material. We saw what color these materials are. They were a greenish color. We saw that they were near the nickel tanks. We heard testimony. Regarding what on-site personnel told our witnesses, told the inspector when these things would be cleaned, what these solutions and these materials likely contained. Once again, the spill cleanup requirement is not that it must contain nickel. It is that it may contain a metal. Thus, we are requesting these findings and the conditions. We do not believe that valley plating shall walk or step on drip trays or other collection or containment devices. That is contrary to the purpose of the rule. And once again, as I said, after we leave the hearing board, if you do not find that they shall not walk or step on these drip trays, they can walk on it all the time, and there is no requirement for them to clean it. Thank you. That is my closing.
Mr. Pomeroy.
Thank you, Mr. Chair. That was quite a presentation. Valley plating is using an approved cleaning method by washing down an area to access it. It doesn't matter if it was on top of the tank, around the tank, under the tank, within the tank. I mean, as long as it's an approved cleaning method that's being applied, then we comply with 1426. So this whole fiction of, we're afraid they're using it as a walkway. Well, it's a little difficult to use a walkway if the only way you can use it is that you always have to tether up in order to even access an area. So we've suddenly got people that are deciding to use a walkway with a tether device. Nah, it doesn't make sense. Doesn't make sense at all. Let's talk about risk. We do have nickel tanks, no hexavalent chromium, but we do have nickel tanks. The nickel tanks have always had counterflow rinse operations used in them. This isn't a new thing. It's been there forever. They're essentially exempted from virtually everything under 1426. I know they may contain metal, but again, we're talking about possibility of metals at some amount. Now we get them down into a tank pit that is as deep as 5 feet deep. There are no walkways through there. There are no people commonly accessing the area. It's cleaned before it's accessed. This whole fiction of the hose being the contaminator and being carried out as a problem doesn't make sense. The hose was brought over there. It's used to clean up the area. They need a hose to put low pressure water on it, which is one of the approved cleaning methods. And so the containment pits are just that. They're containment. There's no airflow through the area. There's nothing that is occurring that causes a fugitive emission to be generated out of the containment pits. That's not what they're they're prepared for. They are cleaned daily though. And if we were just following the district rule, we wouldn't have to clean a containment area except weekly, but we're cleaning them every day. We're cleaning the tops of the tanks every day. So we are actually exceeding the cleaning requirements if these were all deemed containment devices. And we think that's a reasonable approach to this whole thing. So we really don't see a reason why the district needs to agree that anything that is not a containment device, and I did not get an answer from either inspector with regards to anything else being a containment device. They couldn't give me an example, yet there are some. We don't know what they are, but we offered what they were. And we think that should have merit in this process. And we think there's a reasonable approach to this. We've suggested it. We've heard some of the board members making reference to the ideas we've thrown out about a week in daily testing or daily cleanups and things like that. We're fine with that as a process because it's reasonable. We're just trying to get away from the got to have a full-time employee walking around worried about a drip that might somehow not be deemed within the district's narrow confined definition of a containment device, which they can't tell you what they are. And that makes it very difficult for the industry and the person that has to comply with this regulation to comply. They don't know what it is. They say, well, we know it when we see it, but we can't tell you what they are. That's not very helpful for us. We do need to know. We can't walk around the facility and test every hour and do sample or do cleanup every hour. We can do it every day. There's a reason, and we will do it every day. If that's a condition, we can live with that condition. Very happy to do so. So, from our perspective, we believe that it would be inappropriate for the board to agree with the district's position and their suggestion of requirements that they would like to impose upon valley plating. And we have suggested alternatives. Thank you.
Thank you. So just a quick question, Mr. Pomeroy, just
Yes.
want to make sure we're clear.
Yes.
You've agreed to Exhibit 1, the stipulated facts and conditions,
We have.
okay?
That's correct.
But you've not agreed to Exhibit 2.
And just so you understand what I'm getting at, and it doesn't get confusing, and we're talking attachment B specifically within the attachment 1. So I just want to do this so you understand why we're here today, because there really is a reason. Look at condition number 13. It's very important. We're agreeing to that. But you're going to see why this now becomes a question mark. Not to be flip about it, but we will comply with 1426E3A. We understand it to mean a certain thing. The district has meant to understand it, as we're hearing, to mean something else. So we really have to have an understanding of what containment is and spills and all those other things, and we will happily meet that. 13. But if we have a situation where it's going to mean we're testing that we have to somehow, everything's a spill, I would say we cannot agree to number 13. Because we don't believe that to be a case. It would be the end of the company in the sense of we have to have full-time employees to walk around for spills.
Where's your alternative language?
Oh, for this?
Yes.
As I said, we're in agreement with it as we understand the rule to mean under 1426E3A. As we understand it to mean, a containment device is all these things we've described.
Okay, fair enough. All right. Mr. Balakapalan, so we're done with closing arguments. We're now down to deliberation.
Yes.
May I make one comment to
Sure,
clarify
absolutely.
what I think Mr. Pomeroy's point is that they're agreeing to comply with 1426E3A, but they do believe that the area beneath the pits is a containment device. The district does not. So that's the point of the dispute. Like they are not agreeing to this if the if the area under the pits is not considered a containment device because they do not agree to clean it weekly.
No, clean it hourly.
I meant under 1426E3, they would be required to clean it weekly. If the pits are not considered containment device, then it would be considered spill that they would need to be cleaned hourly.
See, and so this is the number one reason why I really was trying to focus us on Exhibit 2, because we've gone through this entire exercise. We all agree to Exhibit 1. We all agree. So now we're down to deliberation, and we still have yet to really unpack and unearth Exhibit 2. And so now, at the end of the day, no pun intended, we never heard from any aspects or arguments vis-a-vis Exhibit 2 until a second ago. So at any rate, I mean, so we're going to go with Mr. Pierman, then with Mr. Balakapalan.
So, yeah, I understand the consternation you just expressed. Yeah, I think first, given the vagueness of the rule and kind of the uncertain testimony of the district witnesses, there's no reason to overreach here from our standpoint. They didn't test the material, so we have to assume, we don't know that it was metal or whatever, or nickel. There was reference to one violation back in 2020 from a witness who really didn't know much about it and was just read off a screen. And as far as we know, nothing else since then. So I don't think we can presume there's been a problem here at all. So it seems to me that we should not, grant the findings requested in attachment C by the district. I think we can rule, they can stipulate. If not, we can certainly impose these conditions. And when the time comes to make a motion, I'll do so. But basically, that they'll follow a management practice of not walking on the containment pit, collection area, drip tray, except as needed for maintenance of facilities or to clean such equipment. They will clean those areas daily, including cleaning any liquid accumulation at the end of the workday. That language is intentional because you don't want some liquid to accumulate at 1, but they cleaned at noon and then it's on a Friday and it stays there till the weekend. Right. So sweeping, if they sweep at noon and nothing else happens, great. But if there's liquid accumulation at 4 o'clock, clean it up by 5 o'clock, close the business. Mm-hmm. And then I think we would just simply state to deal with the issue raised, since the order already talks about complying with the rules, so there's no confusion. We'd say in following these conditions, Valley Planning be deemed compliance with any related and applicable requirements of Rule 1426 and 1469. So there's no confusion by the district and the respondent. And lastly, I point out that we do have in the conditions approved coming back in June 18th, 2025. So if it turns out that they do some studies and find there's some fugitive migration, or if they find that the pit doesn't work as represented here, then we can revisit the issue and find that it is something that's subject to the rule as strictly interpreted by the district. But the facts presented by the district simply don't meet that verdict at this point in time.
Mr. Balakapalan.
I was going to say, I've been to quite a few plating facilities in my career at the district, and I've been to a facility where they were contaminated the ground. It became a Superfund site because they didn't have secondary containment. It became in Riverside, so they had to, EPA had to take over and it became a Superfund site. He moved over some area, remote area, and he thought, unfortunately for him, the inspector showed up there too, and we went there, but he learned his lesson. He built secondary containment. And the secondary containment is for that purpose, so that they don't migrate into the soil, into the water table. So any spills, which will happen in a plating shop, it's not a clean, pristine operation. It is contained. It does not, so it is an air issue too, because if it dries, that's what the fugitive emissions are, because if it accumulates and it dries up, and I think 1426 addresses it properly by saying, hey, you got to clean up too, because don't let it just stay there for months, So it is an air issue also, and waste management issue. So, and I agree, I think we can, there's stipulation, the condition 13 says it shall comply with for E3A, but I think we can either change that, there's no stipulations on 13 on, E3A as unless the understanding is that it's cleaned once a day and that the area under the tank is containment. But I think the district position is it's not containment. So I think we could take out condition 13 from that stipulated order and craft another condition. I don't know what.
Well, I thought Mike,
Yeah.
third point dealt with that.
With that? Okay.
That
Yeah.
dealt with that.
So-
So you couldn't interpret it differently.
We leave 13 in and then add the language as an addendum. Ms. Verdugo Peralta.
Thank you, Mr. Chair. I can live with that. What I couldn't get through today was why we went through all of this when we were, as Mr. Ali said, the chair said, we needed to focus on number 2. Nowhere does it say in here that we're requiring you to have somebody 24/7. We have had cases when we have required them to have however many personnel, how many hours a day they had to be there. They had to have specific training. That's not what's being asked here at all. And the fact that if they can live with the conditions in the original, was this number 1? Yeah, number 1. I don't think it's a huge step. I think you're reading into it too much and thinking that we're requiring you to do much more than what it states here. I like what Mr. Pearman has said. Maybe we can live with that. And the fact that we will be coming back in June, if this doesn't work out, then we can address it then. But I just wanted to make sure here that we keep in mind where this facility is and who the people are that can possibly be affected. That has always been my concern with this, and I think we just went way over what we needed to do to get to the point of Mr. Pearman's offer to make that motion, and that the conditions, as long as they are met and as long as it works out, I'm okay with that, because I think it would still be within the realm of making sure that we are adhering to environmental justice issues and concerns.
Any further deliberation? Mr. Pearman, why don't you go ahead and proffer your motion?
All right, so what I proposed, Mr. Clerk, is 3 conditions, and I'd list them after number 13, so it just reads a little bit better ultimately. So this would be 14, 15, and 16, and you renumber the other ones accordingly. So 14 would be that the Valley Plating would agree to follow a management practice of not walking on the containment pit, collection area, or drip tray, except as needed for maintenance of facilities or to clean the containment pit, collection area, or drip tray. And then proposed condition 15 would be that Valley Plating agrees to clean the containment pit, collection area, and drip tray daily, including removing any liquid accumulation at the end of each workday. And then paragraph 16 would be, in following these conditions 14 and 15, Valley Plating is deemed in compliance with any related and applicable requirements of rules 1426 and 1469. It would be great if on the record, one or both parties stipulate to that, but if not, then we would just do it our own on good cause.
Is there a second?
I'll second it.
Second by Mr. Balaka-Palan. Any further question or discussion on that motion? Hearing none. Dr. Abraham.
Aye.
Ms. Verdugo Peralta.
Aye.
Mr. Balaka-Palan.
Aye.
Mr. Pearman.
Aye.
Ali votes in the affirmative. I presume that both sides are in acceptance of
I will so stipulate to the proposed conditions.
Ms. Sue.
We do not stipulate.
Okay, very well. So let the record reflect that the district does not stipulate. The respondent does. This case is approved unanimously. We are off the record at 3:33 PM and adjourned. Drive safe.
There you go.